Look through the file, the last uniform child support order was from 2015. Is that correct, ma'am?
Yes.
All right. I don't have a problem. Are you still working, sir? I don't have a problem referring it to the front of the court. It should be because you're 9 years old, but I'll tell you the chances are it's going to go up. And
For the medical bill, for the insurance.
you are to, you asked to have your child support lowered. And I'm going to refer it to the friend of the court for that. And as far as, I mean, you owe a certain percentage of medical bills as of right now, 44%. You got to pay it.
He's under my insurance. They made me put him under my insurance and then sent me the bill.
Who sent
Well,
you?
he was covered under Medicaid. The state.
Why is the state paying if you got medical insurance?
I don't know. They made me put him on my insurance.
Well, the friend of the court, ma'am, my understanding from your response that basically you turned the bills into the friend of the court for medical, right?
Yes, the request for his 44% of the bill, I believe, because I get some assistance and they made him get health insurance for my son, and that's why he had to get insurance. But Medicaid is a secondary insurance, and the bill that I'm requesting help with, Medicaid won't cover it because it's more of like a psychological therapy type
Yeah, with
like,
brains.
yes, and
And
Medicaid won't.
All I tell you is this: anything that is not covered, you turn into the friend of the court if he doesn't pay it. Okay, if he doesn't pay his percentage, and that's what you've done.
Can you repeat that? Sorry.
Anything that is left over that is not paid, all right, on that.
Yes.
You can turn that into the friend of the court if Mr. Hill does not pay it. You turn it into them and they will look at and determine appropriate enforcement for that.
They said that he has to pay 44% of his share because they said I have to pay the first $357
as ordinary medical
of the calendar year for the calendar year, and then his dad has to pick up the 44%.
They should provide you with a statement of that, and if you object to it, it ends up in front of me, and then I'll make a decision. But if there is money that is left owing and you owe 44%, then you owe 44% of it. It's right in your UCSO.
Right. But he's under my own insurance.
I know, but if he's not, if you can have insurance and they don't cover something, okay, at that point, it comes back to me to determine. You're going to owe your percentage for his medical that is not covered, whether it's on your insurance, her insurance, or Medicaid.
Can I speak
briefly? What?
Me? Because I have this bill here. I have to pay more than he has to pay. I have to pay $357. He only got to pay $8, or not $8, but
that's ordinary medical that you have to meet first. All right, I'm telling you, if you have questions about it, you send it to the friend of the court. They do an investigation, and if there's no agreement, then it comes in front of me with their recommendation.
Right. Okay.
Right. That's what happens. So if you don't pay it and they say, we think he owes it, it'll come in front of me and I'll make a determination at that point. But as of right now, I see nothing. If it's not covered by insurance, your UCSO says you pay 44% of it. That's what it says.
But he was on Medicaid.
If Medicaid didn't pay it, I don't know. Okay.
Medicaid didn't pay it.
I understand. I don't care how many medical insurances are out there. If it didn't get paid by any insurance, 44% is yours.
Right, I understand that.
And that's what she's saying is it's not covered by anybody.
$740 every 2 weeks.
Again, I'm going to send it to the friend of the court and we'll figure out what your appropriate child support is. It hasn't been reviewed in 9 years. We're going to send it there. They'll be in touch with you, ma'am, and you figure it out. Do what it is, and then we'll see what happens. So I'm sending it to the friend of the court for child support review. All right, ma'am, they're going to contact you. Make sure you cooperate with the friend of the court. Thank you very much.
Okay, thanks.
All right. Thank you, sir.
How do I get off here? How do I get off? I'm trying to get off. Sorry.
That's all right. We can probably, McKee versus Stokely. This is a motion that was filed by the plaintiff mother regarding custody. She's seeking a change of custody in this particular matter. The primary complaint is that one of the boys, Hunter, was inappropriately disciplined by Mr. Stokely's, I think it's his wife. So certainly a significant other. I'm not sure if they're married or not.
Girlfriend.
And there has been claims that that was clearly excessive punishment, taping his mouth shut. CPS, I don't have a CPS report of any kind.
I filed that under seal, Your Honor. With this motion.
Well, I don't have it. But I'm accepting the fact that CPS became involved in this case. I don't know, maybe they substantiated. I think there was some kind of a safety plan put in and whatnot. But Ms. Dawson, well, Ms. McKee, is there anything you want to add?
There was also an incident in the CPS report that I did submit to, so I'm unsure where that ended up. But there was also an incident where Mr. Stokely and his girlfriend, Katrina Hunter, after I told Mike what had happened, what the boys had told me had happened, were driving down I-96 and she grabbed the steering wheel, causing them to swerve all over. And all of the kids gave statements to CPS and they substantiated that as well.
Okay.
But they put the kids at an unreasonable risk of harm.
But they left the kids where they were, right?
The kids were in the car when they were.
No.
CPS?
They have not filed any kind of petition or anything like this, or to remove the kids or anything, correct?
No, they told me to take it to court, and they're working with the Right Door, I believe, Michael and Katrina and the kids. They're
Okay.
in services.
Okay, so they have not said any type of, obviously they aren't making any type of change. I deal with that all the time. All right, Ms. Dawson, any response?
Oh, I've got a lot of response, Your Honor.
Well, you're not gonna have a lot of time.
I will make it quick. First of all, the CPS report that Ms. McKee is indicating or is referencing, it's my understanding from Katrina, who is my client's girlfriend. She's hired an attorney, and the portion related to the tape over the child's mouth, that has already been removed from the report.
No, she even admitted in it. And
No,
it's
Don't
not-
interrupt.
It is my
You'll
turn.
have a chance, but don't you go interrupting. Go ahead. She says
Thank
it's
you, Your Honor.
moved from the report.
Yes, that has already been removed from the report. Now, I will be honest, I only received notice of this hearing 3 days ago by talking to your clerk.
Now,
So
wait
I
a
have
minute.
not
You
filed a
filed
response.
and that you asked that it be adjourned 2 weeks ago because nobody was gonna be here. You knew it was adjourned. Don't give me that. You're here. and you
Notice of the
should have
date.
known it. What?
I didn't get notice of the date.
Well,
I had
then,
no
doggone,
idea.
I should have just had it 2 weeks ago then. You asked for the adjournment and we adjourned it for 2 weeks. Don't give me that. That's not going
Did
anywhere.
not get the
Not going
notice.
anywhere with me. I'm telling you. We adjourned it at your request, even at an ex parte, at your request. We adjourned it, all right? For 2 weeks. I don't care. You should have known. We're going ahead with it. That's not an excuse. Go ahead.
All right, Your Honor. Further, it's my understanding that the CPS report that Ms. McKay is relying on is likely to be overturned. She has an attorney. They are working with CPS. Further, it is also my understanding, and I will get the CPS reports if we proceed to a hearing, that there is question as to another case involving Ms. McKay and her other children in Ottawa County, and that CPS has found a preponderance against her in that case because she has convinced the children to lie to CPS for her. My client has provided me with the names of an individual who would be able to testify to that he has actually witnessed Ms. McKay encourage the children to act out and misbehave for Mr. Stokely so that she can get custody back. So it seems pretty clear to me that she is using CPS as a sword and weaponizing them against Mr. Stokely. And, you know, frankly, Your Honor, it seems pretty frivolous that she's relying on a CPS report that could likely be overturned.
Well, it's likely. I mean, geez, oh, Pete, that's out there. It is a report now and it does substantiate now. And Mr. Stokely is involved in my understand, a safety plan of some sort. Isn't that correct? Or he's going to some place that she says he and his wife are right place or whatever. You're not.
Mr.
you're not
Stokely, I'm
availing
gonna
yourself
ask you
of
to
that?
clarify.
The CPS has not set up a safety plan.
Well, that's not good.
Because
Are you
we've
attending
already been
something at
receiving
their, are you
services.
attending something because of their request or something like that? Some type of a program?
No,
Did they suggest one?
no. We're already receiving help from Right Door. We have 2 counselors in our home at all times.
That's what I'm talking about right now. Was that in place beforehand or what?
Yes, that's something we took the initiative to set that up ourselves.
Okay, but was that after the alleged tape?
No.
incident?
It's been set up for a year.
For years?
Yes.
All right. Ms. Dawson, you can finish your argument, then I'm gonna go back to Ms. McKay.
Well, Your Honor, I think it's pretty clear that there's a lot going on in this case. You know that better than I do. But I don't believe that Ms. McKay has met threshold to change custody. And if we proceed to an evidentiary hearing of some kind, I will file a counter motion.
That's fine. Ms. McKay, you can respond briefly.
So as far as the Right Door services, Hunter started attending those and Cameron only a couple months ago when Mike and Katrina, without consulting with me, switched Hunter's counselor, who he was with for 3 years, switched it to the Right Door. I'm not sure that the timeline, it was right when they started getting the CPS services or CPS substantiated. So I'm really unsure why he's saying it's not.
All right, so
It's been going
tell
for
me,
years.
what, you're not an attorney, but tell me what the change of circumstances are to meet with what I would consider Vadvarka. Proper change of circumstance to have a hearing. I'm not gonna change any custody, no matter what today. I'm not.
Yeah. The threshold would be the substantiated CPS case abuse, and then also their domestic violence or swerving on the road, arguing with the kids in the car, putting them at unreasonable risk, and other substantiated case.
All right, well, I doubt that's going to raise to that level. However, the most that I can do is, I will set a brief. Oh,
We already scheduled that from the June 28th motion regarding.
we have an August 6th evidentiary hearing.
Well, I was actually gonna ask, I got notice of it, but I know that there is a companion child support issue that I'm not really involved in, that Ms. Pauletta and Ms. McKay's previous attorney, that was an issue, it was outstanding. The agreement was Ms. Pauletta was gonna hear out the child support issue, and then I would take over the case with this new motion. So I am actually unclear as to what the August 8th or 6th hearing is for. I have it on my calendar. I'm prepared to.
I
proceed.
haven't even been notified of it.
Ma'am,
Well,
you were
I didn't
mailed the
request it.
notice of it back on June 17.
I never received it.
Well, that's, there's a shocker.
Can I
Everybody always
get it
says they
remailed
never
to me
get-
or
They
something?
never get noticed, no matter how much we send things out. The person who doesn't like it never gets noticed. There's notice of a August 6th from 11 to 12.
Well, if it was
Evidentiary
referring for the
hearing.
child support, it went to my attorney, because I do have the attorney for the child support case. So that might be why.
I'm assuming.
I can try to. let
Who's
me-
your attorney on that?
Rob Carpenter.
All right. Maybe that's what it was set for. Do you know what it was for sure? We can go back. I'd have to go back.
Hold on, Your Honor, I can tell you.
531.
There's a
It
motion
is
to change custody. It is what?
the in-person evidentiary hearing on August 6th was sent to Mr. Carpenter. But the notice does not indicate if it's specifically.
Well, no, it was sent to him, and everybody other than me probably knows what it was for. I'm sure I set up the hearing because there was an objection. It sounds like it was an objection to child support. We've had meetings about child support. I know in the past that apparently still haven't been resolved, so we're having that hearing. I'm gonna set up a evidentiary hearing regarding threshold. I don't think at this point it is met, but there are arguments back and forth. And I'll set up a hearing for the threshold only, ma'am. That means that I'm going to determine if there's enough evidence to have a custody hearing.
And Your Honor, may I seek clarification on one thing?
Yeah.
Okay, so when we were here previously, you stated that Katrina, Mr. Stokely's girlfriend, could not be alone with the children. Are you able to clarify? That just means that she's not to be alone with them, but as long as like her mother or some of the other children or Mr. Stokely or someone
Not
else
the
is
other
present.
children, an adult is around somewhere. Yeah.
Okay, that's
not-
acceptable.
That's what the order said. She's not to be left alone with them, okay? That means Mr. Stokely can't just leave and leave her with the kids, all right?
But as long as there's another adult present, that's
Yeah.
acceptable.
Yeah, I'm not trying to break up their relationship and stuff. I'm just trying to get to the bottom of some of these problems here. And there clearly was some questionable. It was not specifically directed. In fact, none of this that she is saying is directed against Mr. Stokely. It's all against the significant other, the taping of the mouth, the supposed fight on the highway and all that kind of stuff. All I'm saying is she can't be alone with the children. There has to be another adult there, and that's fine.
And Your Honor, just real quick, I have information that the children told their counselor that none of the stuff on the highway happened.
That's
I'm
fine.
gonna get- Can we
What do you
overturn
expect me
that?
to do here today? I mean, seriously. Yeah,
Okay.
you say it didn't happen and she says it did. All right. That's
All
why we're having an evidentiary hearing. All right.
Fair enough.
Bring in some evidence and we'll see what happens. So we will have only a threshold hearing, ma'am, which means you got to show that there's proper cause or change of circumstance to have an evidentiary hearing for custody. As of this time, that's all that is set. I'll see you here on August 6th, I guess it is, for the other evidentiary hearing, which must pertain to apparently child support, which I've met with both counsel at least one, if not two times, and I can't believe I'm still having to have a hearing because we could have had that hearing on this threshold instead and save that time. But if you're continuing to fight this, I'll do the evidentiary hearing on child support on the 6th. Good luck, everybody. We'll set up a hearing. We'll be in touch with your office, Ms. Dawson, to make sure that you can be there for the threshold hearing. It's not going to be a long one. All right. Parties are going to be expected to get to it right away. All right. And I'm not going to set up a all day or maybe even an all afternoon. Might give 2 hours. That's because all I'm finding out is whether there is threshold to have a custody hearing.
Got it.
Good luck, everybody. Thank you. We're adjourned.
Thank you.
Yes.
Ms. Antoine, are you there? Turn on your
I'm here.
I hear you. I have
Can you hear me?
Samuel and
Yep, we're here.
who's with you?
My son.
Not there. Tell him to leave. No, that doesn't just mean move the camera.
No, he's walking away right now.
Show me. This is the case of Antoine versus Ann. Parties are present via Zoom. This is defendant mother's custody motion. There was an ex parte motion where I believe the mother had extended parenting time. She was to bring a motion to extend that or to deal with it. Didn't do it in a timely fashion. Has reasons in here why she didn't, but the ex parte was dismissed. She claims in her filings that stepmom is mean and violent to the child. Dad is violent, and she shows me a couple pictures of bruises, although they're not dated. I don't know much about them, but I've seen them. Says the school improved over the last 2 weeks when mom had him only. He doesn't eat at his dad's house. He's forced to, when he works, he's forced to turn over some of his money for food or toiletries, etc. Mr. Antoine, I didn't see you filed any response, but it seems to me that you, when we were here last week, that he's disrespectful and you say you don't assault him. Ma'am, what do you have to add? Because you have to show proper cause or change of circumstance for a custody hearing. What is your proper cause or change of circumstance that you think is appropriate? Ma'am?
Yes.
Yeah. What is it is proper cause or change of circumstance to have a custody hearing?
I believe that the situations that have happened with Cameron over the last like 3 months with his dad is the reason we should have the change of custody. Cameron, You know, I know that he has said that he's just disrespectful, and I think that it's a lot deeper than that. And Cameron's not a bad kid. I don't have those issues that they have over there with him as far as being disrespectful. The disrespect comes from a lot of things that happen in that household, and Cameron's not a bad kid. I
didn't say he was a bad kid, but now you just kind of admitted that he is disrespectful over there.
No, I'm saying he's not disrespectful.
You said his disrespect comes from stuff that happens over there.
Right. Like there's certain situations that have happened in there, and the reason for their issues and the arguments that they have are from things that happen over there. I just believe that there's a lot of picking with Cameron. There's a lot of things that happen that.
Well, tell me what. I mean, because I don't find it inappropriate that if he's working, that dad teaches him something that he's got to pay some of his own bills and stuff like that. There's nothing wrong with that.
No, it's not inappropriate to teach him responsibility, but some of the money that he's getting when he's working is going towards groceries in the house for everybody. I feel like as a parent,
that's not abuse or neglect. I'll tell you that.
I feel like as a parent, you should teach your kid responsibility, and I do the same thing here. Cameron pays part of his phone bill here. We have him in a savings account with a decent amount of money in there to teach him responsibility that he has to buy his own car and everything like that. But I don't feel like when you go on a family trip, you should have to pay your way to go. You know, he had to pay $120 something to go on a family trip towards groceries and gas, and he was the only one that had to do it. And one of the other kids in the household had a job that didn't do it. I just think that there's a lot of things that happen that aren't right.
Well, I'm not going to get into the middle of parenting, quite honestly, and decisions on who makes what kid pay what for toiletries or whether he contributes to a family vacation. That doesn't meet with Varka at all. But what are you say there was abuse, but there's no CPS or police reports, is there?
Yeah, we don't have the CPS report. It was not done in time for our court hearing. But there is a CPS report that I put a request in to have already, but it's not here yet.
You don't even know what it says.
No, I don't know what it says yet because like I said, that they don't have the report done yet. I had just reached out to the CPS worker the other day to see if they had it ready yet, and they don't have. They're going to mail it to me as soon as I can get it. I put the request in already for it, but they don't have it all the way prepared yet.
All right, sir, what's your response?
With the CPS report that she's talking about, I got a call from CPS. They said they canceled that case because the only reason that my son had that bruise on his arm because his mom instructed him to come to my house and tell him to not give me his phone because he was disrespecting me and my wife. So by him saying that, so I was trying to grab the phone out of his pocket. Therefore, by me grabbing his hand was like friction from me grabbing his arm.
We'll see what CPS says. I don't know if they're going to substantiate. I don't know if they're going to do anything.
Yeah, they already called me and tell me they canceled the case. I got the.
I understand, but that's as much hearsay as she's saying as far as it too. Okay, I just don't have anything.
Yeah,
I got
the evidence and stuff to bring in, and then all the accusations she made on the paper. I got all the evidence. I got the videos of me grabbing the phone from his pocket. I got all this stuff, all the proof. So
okay, well, what? Anything else?
Because my problem is that as a father, all I want to do is take care of my kid, teach him responsibility, and when he's failing at school, and accusing me I'm the reason that he's failing school, to where the days that he's with her, that's when he's not going to school. And that's the same thing I went to court before. And I have the proof from the school and everything that's where the teacher emailed me, say, hey, he's not doing schoolwork. He's not doing this. And I have all this proof. The reason we have a misunderstanding is because he have chores. He have responsibility. He have schoolwork to do. He's the only kid every time he come home and saying that I don't have no homework, to where the teachers message me and say, hey, Cameron's not doing his work. He has time after school to do work or time in class. He's just not doing it. So that's the issues we have.
Well, this sounds to me like a kid playing both sides of the fence, which is not unusual, even if both parents are together.
That's not necessarily the case, though. I have Cameron in a counseling session right here. And to be quite honest, there's a lot of things. it's not just Cameron being disrespectful over there. The reason why Cameron was instructed to call me if anything was happening, or, you know, to not necessarily just give him the phone, because every time he goes over there, he's getting threatened that they're going to break his phone with a hammer. And the reason why Cameron didn't want to give him that phone is because it's not.
Fight over a phone?
Huh?
This is a fight over a phone?
There is a fight over the phone because Cameron doesn't feel safe over there.
Because his dad's gonna take the phone away?
No, because of the way that the stepmother treats Samuel, the fact that Samuel lets the issues happen, it's the way that he's talked to, he's disrespected over there. There's so many things that we can't just sum up in one video, and we can't write down, you know, one court hearing. It's a lot deeper than it might look petty on the scene, but when you really sit back and look at it, it's Cameron's not comfortable there. He doesn't want to be over there.
Because dad's gonna take his phone away, and because dad says he's not doing his homework and he can come home to you, and you're much more, oh, you're all right, Cameron.
No, that's not how it is.
Well, that's what I hear, okay? And so what I'm gonna tell you right now is I don't think there's Vedvarka to have a custody hearing. However, when you get that CPS report or something, and if it shows something different and you wish to renew this motion, I will gladly hear it. All right? If there is something that seems to be of concern through CPS or something like that, that's appropriate, and I'll be glad to hear a motion on that. The reality is he's 16 and a half years old, and you guys are losing control on him all over the place. And you're not working together at all on raising this child. The child goes to two different places and is treated differently and uses one against the other and all this kind of stuff. If you have something from somebody, an independent source that indicates that he is, you know, being beat or inappropriately disciplined or something like that, you can bring this motion back, all right? But I just don't have anything here now to have proof for what's called Vedvarka, proper cause or change of circumstances. I don't have any kind of preponderance in front of me at this time. So I'm going to deny your motion with the understanding that if you wish to renew it with further evidence or further, you know, something, counselors, CPS, some of these things that they're independent people, I'll be glad to hear it again. So at this point, I'm just going to deny the motion for change of custody. And ma'am, if you wish to, like I say, if you wish to come back with something of substance that you think I should look at and find as substantive, I'll be glad to look at it. Good luck, everybody. Thank you.
Thank you.
28.
That's all I got.
And this is the last one today? We're done?
Done.
Great. Guys sitting back there just watching us.
I did email the attorney to see if they could possibly log in earlier. But you're not sitting here till 10:30 today. I heard back.
No worries.
Who's the attorney?
Scott.
All right, it's Munez versus Rosario. Mr. Rosario is here, Miss Munez is not.
She's not feeling well today, sir.
Why, she live with you or what?
No. I'm homeless right now. I'm at my friend's house to do this interview.
Right, well, Ms. Brower is present for the prosecutor's office. This is her motion for an order of support. There are guardians involved in this case, as I understand, co-guardians.
Yes, sir.
And Ms. Brower, you're seeking an order to get support to one of the guardians. Is that correct?
You're cutting.
Hold on, sir. Hold on, sir. Just let Ms. Brower, I'll talk to you in a minute.
That is,
Yes.
yeah, absolutely correct, Your Honor. At the pre-hearing conference on May 28th, 2024, that's when I found out that there was another guardian on this case. So what I did, I proceeded to run guidelines with dad paying child support. The recommendation was $286 per month, but since the child spends 184 overnights per year with the plaintiff on this case and the remaining time with the co-guardian, I essentially divided the child support recommendation by 2. Now, both of the parties agree. Both of the
Again, stop. I'll give you a chance. Next time you do it, I'm just going to mute you. Go ahead, Ms. Brower.
It's my understanding that both of the parties actually agree with the recommendation, Your Honor, because I sent it to the defendant via DocuSign and he e-signed it. So then the plaintiff does not use email. So I printed it and mailed it to her by first class mail. She signed it and returned all the documents to me, but I remailed the documents to her because she forgot to date them. And then I never got them back from her. So that's why I set it up for a court hearing today.
Basically, you've had signatures on this for both, but not a date for one of them.
Correct. Yeah. The guardian, the plaintiff forgot to date it.
All
So
right.
that's why I just decided to set it for a court hearing.
All right, Mr. Rosario, now is your time. You may talk. What do you have to say? Nothing?
I can hear nothing you guys are talking about.
Well, that's at your computer then. You said you could hear me earlier.
All right.
Does it show he's connected?
Yep.
Shows you're connected. I'm waiting for you. Well, you got to do something. I can't fix your computer.
I don't read lips. I cannot hear nothing you guys are talking about.
Then work on finding a way to hear it. Staring at it isn't going to work.
It's cutting in and out, in and out.
Well, it's not from my end. Well, I don't know. You keep telling me you're not getting it, but you're not doing anything. Log off and log back on.
Let me check. Let me check.
Hello.
Can you hear me?
Yes.
I cannot hear you guys at all.
What'd you take?
Yeah, volume's up. Everything is, I was listening to you guys and you just start cutting in and out.
Well, I don't know what to say. You're the only one. Tell them to log off and log back on.
Can I try to call and the number and do it through the phone?
You,
Did he say yeah?
I don't know what he said. What? Ask him if he objects to this order being entered. And why, if he does, why?
Yes. Let me call the number.
All right. That's the Zoom number you gave him?
Let me call the number.
Ms. Brower, this is all your fault.
I know, I'm the bad one. I know.
At least I'm assigning the blame to you.
That's okay. I can take it.
Yeah. I think the solution is in-person hearings, probably.
That you're gonna have to start taking.
Other than in-person has frequently in all the years gone by resulted in police being here because people fight in the hallway and they fight, and that's the bad part.
Sure.
You know, you have to have security during motions.
Absolutely.
Well, let's see what it says.
I said Mike J.
And they're not connecting.
Hello?
Can you hear me?
Yes, sir. Yes, sir. Now I do.
All right. You're Mr. Rosario, right?
Yes, sir.
All right. Prosecutor.
Sorry about that.
That's all right. We'll get to it. The prosecutor wants to enter this support order. She has indicated to me that there are co-guardians, and so she has basically reduced the amount to this particular guardian, which is Miss Muniz.
Muniz, yes.
By basically half, because she doesn't have the child full-time. All right?
Yes.
So what do you have to say?
Okay, in the paperwork that I got here, my thing, the lady that I spoke with, I told her that I just got out from jail. She put the date from jail time wrong. She put 2021 on June 2021, but that's not the right date. It should be 2022. And the petitioner is demanded to have net earning. They say 1,347, but right now I'm not even working. I haven't been working. I was in jail for a year, and I got out on February 4th of this year, and I haven't found no jobs yet.
The prosecutor.
But I got here in the
The
Yes, sir.
prosecutor has indicated that she has imputed income because you've been out for 5 months. Basically, you have to get a job and you can't just not pay for it. And as a result,
Okay.
she is saying, and the only thing that I was unaware of, and I will ask you, Ms. Brower, is I don't see what the imputed, I see the total amount, but are you imputing him at 1033 for a certain number of hours or something?
Yes, Your Honor. I imputed him to minimum wage, which is 1033 an hour, and I used 35 hours per week. I was trying to work with him because he did explain to me that he's homeless. And so that's why I imputed him to like the bare bones minimum to give him an opportunity to find stability, get a job, so that he can pay this support recommendation.
All right.
Yes, sir. Yes, ma'am.
Well, I kind of have to impute you because you have to get out and work. All right. And I'm not saying.
Yes. Oh yeah, I'm working on it. I'm working on it.
And it is the absolute minimum that we can impute you as, because it's minimum wage and most jobs pay a lot more than minimum wage. And so your support is based on that.
Okay.
And we can start, we'll start the support effective September 1. So you got from now until September, and then it starts. All right.
Okay. Sounds great.
143. Ms. Brower, do you have any problems with that?
None at all, Your Honor.
All right. We'll start that on September 1 of this year. Good luck. I hope you get a job. You gotta
yes, sir. Oh, thank you very much.
Thank you. We're adjourned. Thank you.
Okay.
Thank you.
Thank you, Your Honor.
Thank you.
Brower, is that your only one today?
Oh, yes, that's it.
All right. Well, have a good weekend.
Thank you. You did the
Ms.
same.
Lowe, are you there?
Yeah.
I am, Your Honor.
All
Good
right.
morning.
Both parties had logged in at one point, but they're no longer logged in. They didn't call you or anything, or?
No, I haven't received a message.
All right. Well, it's a matter of Hungerford versus Wright. As I've just stated, both parties were logged into Zoom. This was set for 8:30. Both parties had logged in, they've logged out, haven't logged back in. The prosecutor who filed this motion, Ms. Michelle Smith Lowe, is present, and has asked this court to enter a child support order. And basically it's a minimal order. There are 2 kids, I believe, Noah and Luke. And I believe you've asked for a deviation and everything. The parties are sharing joint custody. I assume there is like Medicaid or something involved in the case, so you're forced to file this matter. You've worked with them. You are asking only that the court order ordinary medical to be paid, and that's by is it Mindy Wright is the one paying?
Yes, Your Honor. Mr.
Hungerford?
Yes, they share joint. They share custody, and so we're asking that I've confirmed that Mr. Hungerford is basically the custodial parent, and he's actually, and when I say custodial parent, he's the grantee of the benefits of the state benefits. Food stamps ended June 30th, and the parties only want medical support.
Right. Well, I'll enter your order because it's for the bare bones of ordinary medical, $41 for 2 kids and 24, and it is him that is receiving the Medicaid, is my understanding. He's the one listed on it. So if they come back to you or whatever and indicate that they don't want any more support, and you can confirm that they are not on any state assistance, that's you can deal with them appropriately, and you know what.
Your Honor, and we did have an agreement. We met on May 30th, 2024, and we did have an agreement. The documents were sent to them. Their emails were confirmed. The documents were sent to them through DocuSign, but those documents were returned. Therefore, I scheduled the hearing.
All right, I'll enter your order and you can send it to me through DocuSign.
Okay. Thank you, Your Honor.
Thank you. Is this your last one with me?
That's it.
Wow. Good luck. Have a great day.
You too.
Stevens versus Gross. We have Mr. Gross present, who is the defendant. We have the prosecutor, Ms. Romo present. This is regarding a child, Orlando. This is a request for a judgment of support. She has calculated that each party has actual income, mother $1,000 a month from work, and father works $13 an hour times 40 hours, and has made appropriate calculations for entry of this order. Obviously, there must be some type of state assistance being used. Otherwise, Ms. Romo probably wouldn't have filed this. But is that pretty much stated, Ms. Romo? You have
Yes,
actual
Your Honor,
income?
thank you.
All right, Mr. Gross, what have you got to say?
Well, I came here to get it lowered a little because I had recently lost my job, and I'm kind of struggling for money on my own right now, and I'm
How
trying
did you
to.
lose your job?
I was trying to find something else because I had got I left to go find something more pay, but the job I went to was too hot for my personal health, and I couldn't do it. So I'm currently looking for more jobs because I couldn't meet the $390 a month because it was just a little bit too much for me, and I was trying to find something better for myself. And I'm still job searching. I got a couple interviews. I got one next week on Wednesday, and I'm just
because what it comes out is if you left the job to go to another job and then that didn't work out, you got to support your child. All right.
Yeah.
And people in the real world don't leave a job until they got another job and that kind of stuff. And you're only getting 13 an hour. I'll bet you can do all of that. Go to McDonald's, go to Wendy's. You can probably earn $15 an hour, or at least 13 an hour, and you got to do it. I see no reason to deviate from this. I know it's an amount that's there and it's not easy for you, but the bottom line is, Ms. Rummel, do you have any statements you wish to make regarding his concerns?
No, Your Honor. No, I don't.
Bottom line is, when you've got a child, I don't care what you do if you don't have kids. You can quit your job, you can do anything you want. But when you got a child, that child deserves to be taken care of through your child support, through whatever it is. And it's not a valid reason that you left and just get out there and get a job. The best that I could probably do is, instead of starting it, so you're already in arrears because they've asked that it start on 5/1, which would be May 1. Ms. Rommel, the best I'm going to do for him, I'm going to start it on 6/1. All right. All right. So I'll give him a little bit of a break.
And we'll make those adjustments and submit by DocuSign.
Yeah, it won't be as far behind. Get out there, get a job. I'm going to enter the order, and just like I say, you gotta work.
I appreciate that, sir.
Good luck. All right. Thank you.
Thank you. You too. You guys have a good day.
You too. Thank you. We're adjourned.
Yep.
And you have two against this, with the same.
Correct.
I want to say. Let me get to my notes.
So not exactly, which is why we're here.
You what?
I said it's the same person, but not exactly, which is why we're here.
All right. There's two separate kids.
Right.
He and Owen.
Right.
There's two separate cases. We're here in case C. It's Razik versus Goodrich. Neither party has logged on, according to my clerk. Both have been notified. Neither party has even appeared at the courtroom or anything like that. It was set for 8:30. It's now 9:35. Nobody has shown up. There are two separate cases for two separate kids. Is Della, the plaintiff, is the guardian, right?
Correct.
Is she the guardian for both kids?
Yes.
Okay. And you've gone through and made a calculation, $18 an hour for Mr. Goodrich, times 35 hours. I went through the imputation factors, or the potential income factors, finding that apparently recently he's had two separate jobs at two asphalt companies, both of which he was earning $18 an hour times 40 hours, which is my understanding in effect. You also state he has experience in law care, but I think you mean lawn care.
Yes, I do. Sorry.
I'm just assuming that. He has a high school, he's a high school graduate. We all know that unemployment rate in Kent County is very low. He's not disabled. I know that, there's, the minimum wage is 10.33, but obviously he has shown recently an ability to earn significantly more than that. You have him listed as A1 asphalt and blacktop. So I think it's probably appropriate that we, and just so the record's clear, the guardian is not charged with income because she is the guardian for the two children. Why, I guess the only question I have, and maybe I should know this, but one's a DP and one's a DZ.
So these orders are actually already entered. We had a hearing before your honor in March, and defendant did appear and he didn't object to the orders. The orders were entered and I consolidated them together. However, I was subsequently notified by friend of the court that because there are two plaintiffs on the DP, being guardian and biological mother, and one plaintiff on the DZ, being just the guardian, that these cases cannot be consolidated. They have to be charging separately, even though it's all the same family and all the same payer, being Della Garzik. So I am requesting that amended orders be entered. That just eliminates the consolidation language. That's all that's changing.
And
so
so
that each child will have their own case that their child support is administered through.
okay, and the 468 is due on each of the children, so basically it's $920 some total.
Yes, and because they are two separate cases that credits defendant for having additional children, the order is $212 higher than it would be if the cases were consolidated. However, the friend of the court cannot collect if I consolidate them because there's two payers on one case and one payer on the other.
Is $212 more because they're separated than when you put them together?
Yes.
I might be wrong, but it doesn't seem too fair.
It doesn't.
Since it's all the same, and I think it's appropriate to deviate at least $100 on each of them.
Okay, I can do that.
If you could, for the reason that he was charged as these kids. The two kids live with the same person, and it doesn't seem appropriate that he pays more just because of it being separated as opposed to being put together. All right.
Yes.
So you say it's 212 more?
Yes.
Can we deviate 106 on each of them so that it costs the same amount?
Yes.
All right. Sorry to make you go through that, but it just doesn't really seem fair. All right. He didn't object to the other amount, and so if you would do that, I'll sign those via DocuSign.
Okay, thank you.
All right. Sorry to make you do that extra work.
That's not your fault.
Thank you very much. Have a great weekend. Take care.
Bye-bye.
Thank you. 7-DP Actor versus Lambert. This is a motion filed by the plaintiff mother to enforce parenting time. The last order that was entered by the court regarding parenting time was 11/28/22 and says she gets 3 weeks in the summer, 1 in June, 1 in July, 1 in August, and basically tells her she has to notify you, sir, at least by May 1. Her pleadings and everything say, and it's apparently that she actually notified you of this back early this year, back in January, of the 3 weeks that she picked, and that she has now been denied at least the one in. Ma'am, which one has been denied?
He was supposed to be home 2 weeks ago and he didn't show up to exchange.
Did you get the June?
I did. He dropped him off to me a week late. He pretty much gave me his 2 weeks. He picked his 2 weeks he wanted.
All right. So what do you want me to do right now? Let me, Mr. Lambert, you sent me in a whole bunch of things with arrows and dots and all this kind of stuff.
Holiday wording supersedes Miss Axdorf's request. Miss
Axdorf, what?
A holiday wording supersedes Miss Axdorf's request for parenting time.
What holiday wording?
The holiday wording defined as FOC standard.
What is the holiday wording in the order?
Yes.
That she is saying.
Yes.
What? How? Where?
2018 order clearly demonstrates.
20.
Yes.
What is that? The only holiday we're dealing with is the 4th of July.
Father's Day. Father's Day is
Father's Day to father and Mother's Day to mother. You agree with that, ma'am?
Yes.
So
All right?
her request was to make the exchange on Father's Day, which does not comply with the order. The order also states that we would only make exchanges between 2 and 6 p.m. on Sundays, which, with her request, does not comply either for June or July. And in August, his return to school date is the 19th, which would give her 10 full days documented in my response, and she's only allowed 7.
What
She's
do you
had
mean?
every
What do you mean?
her time.
Return to school. She has to return them after 7 days to you.
And no, unfortunately, if you refer to the August breakdown that I sent in, it gives a clear calendar breakdown.
She gets 7 days. Did she ask for more than 7 days in August?
She did.
From what to what?
She requested parenting time from August 9th to the 16th.
All right.
And
That's what she gets.
No, because
yes, she does. Don't tell me she doesn't. Don't you tell me what I'm doing.
Look at August. She has from the 19th to the 28th by default because of school. That's 10 full days. She only gets 7 days in the month of
She
August.
has to return them on the 16th.
That would be a total of 14 days in the month of August.
She gets her 3 weeks. All right. She gets them.
She gets 7 days in August.
Yes, and she's returning them on the 16th.
But she gets him on the 19th through the 28th because of the return to school date. If you refer to the record,
school, what does that have to do with anything?
August, she gets 7 days.
August, she gets 7 days for her summer parenting time. For her summer parenting time.
August is defined as a summer month.
Don't go. No, it isn't. You
Yes,
don't
it
get
is.
any time. She gets the 9th through the 16th. She'll then return them on the 16th and gets them back apparently on the 19th to go to school.
How many days was Miss Axdorf get in the month of August?
She gets her 7 days plus whatever else goes on beyond that. That it ends then.
What ends?
What are you telling me? She doesn't get any time in August because she's got them for school?
10 days. The order is clear.
No, it isn't. You're crazy about this. I'm going to tell you right now. She gets August 9 through the 16th, period. If you don't do that, I will hold you in contempt. I will fine you, and I will see to it that other things change regarding this. Then whenever school starts, I don't know when school starts.
Why? Can I ask, why would it end? Because he returns to school. The order is clear. June, July, and August are defined as summer months, and she gets 7 days in each one of those months. Please read it to me again.
She gets school.
She has.
She doesn't get school.
When I'm not taking any school time away from her, she's trying to get an additional 7 days when she has 10 days in August.
She gets 7 days as a vacation in that. She can't take vacations with the son or whatever the child is when the kid's in school. She gets school.
Is defined as a summer month. How are we not defining summer as August as a summer month?
It is a summer month in which she gets 7 days of vacation. End of story. All right. You can take this on up. You'll lose everything. I don't care. She will get the 9th through the 16th. If you do not give it, we will be back. Trust me. And you will suffer for that. She gets that week. She gets 1 week so she can go on vacation in June. 1 week so she can go on vacation in July. 1 week so she can go on vacation in August. You get all the other summer weeks, and you get all those other weeks, which is probably about 7. I don't know how many weeks the kid has off in the summer. That's what it is. And then it ends when the kid goes back to school. Everything ends.
The order clearly states defendant father's time shall have parenting time for the remainder of the summer, commencing when school releases and ending the evening before school resumes.
That's right. And in the order, it also says she gets a week in summer, or a week in August, a week in July, and a week in June. That's what it says, and that is what it will be.
So school parenting time is not considered as overnight parenting?
No. School is totally separate. This is summer parenting time when the child is off of school. That's
Well,
what
if
it
you go
is.
by the school parenting time defined in the paragraph before that, it states differently. I'm not trying to fight you,
Yes,
but
you
I'm not
are.
trying to lose
Yes, you
my
are. You're making a
parenting time.
ridiculous argument that you're supposed to get extra time. She's not supposed to get a week in August. It says clearly she gets a week in August, all right? For that is for that. You get all the other weeks other than those 3 weeks. And I don't know when the kid gets out of school, and I don't know when the kid goes back. But she gets one of those in each of those months, and then summer parenting time ends when the child goes back to school. I don't know when he goes back to school, but it's summer parenting time. That schedule is no longer in effect. Ma'am, you will get that week. We're going to enter the order that you get the 9th through the 16th, and whatever else happens, happens. You may have to return them to him on the 16th until the child goes back to school 2 days later. I don't know. I don't know when the child goes to school. That isn't part of this, all right? And if not, you can file an enforcement with the friend of the court. And then as far as next year, so that it is clear, you will make sure that you notify him prior to May 1 of each year of your 3 weeks.
Yes, sir.
All right. That ends that. We're done. Thank you.
Thank you.
Bedalco versus Brandike. Hope I probably screwed up both their names. I don't know. Did the best I can. Can both of you hear me all right?
Yes.
Yes.
All right. We have both parties present on Zoom. There's a child involved, in this case, Landon, who's like 8 years old. We have a motion filed by the defendant for custody. There was a custody order back on 8/24/16. There was also a parenting time order. There was a stipulation in 2019. And the defendant states that the child has moved with the mother to Tawas, on the east side of the state. He wants to change custody so that the child can come live with him and grandmother Laura. I don't know who that is. He says, that the child moved away. And so he would like to change the custody. He says he's a great dad, wants to be a part of the kid's life, and all this kind of stuff. The court will state here that there is no court-ordered legal custody in this case. So quite frankly, she can move. Unless and until there was a legal custody determination, and there has been no court-ordered. This was a support order case in which it's clear through the Verbrugge case that the court would have to find legal custody, and then there would be a legal fight of whether or not she could move. She can move. Sir, I don't know what, basically the only thing that you have pled in here for Vedvarka, which is a change of physical custody, is that she moved. And that doesn't meet the proper cause or change of circumstance. Tell me what it is that you think Vedvarka, a proper cause or change of circumstance, is to even have a custody hearing.
I'm petitioning the court for custody of Landon because I feel very strongly that his circumstances with his mother have and will continue to negatively impact him. She's moved, 200 miles away from family and friends to Tawas.
He's allowed to do that because there is nothing that says legal custody that she can't. I'm just telling you that's the law.
Okay.
Right? If you had filed for legal custody and you had joint legal custody, then she'd have to ask permission of the court to move there. All right.
Okay.
What is your parenting time that you get?
It's every other weekend, and it's usually Thursday through Sunday.
Well, that can't happen, obviously, because the child will be going to school in Tawas.
Correct. That's why I filed for this motion. I want to have custody of Landon. I want him to live with me. That was the whole point of me filing this motion.
And I understand what you're saying, but in order to change that custody, you have to have a proper cause or change of circumstance for the court to have a custody hearing to determine if it's appropriate. And I don't see that you have pled anything other than you want him to live over here, and his family's here, and you know, she's had a child with
And
another
he's told
guy
me-
and this kind of stuff. It has to be something that, a change of circumstance, that I
Sir.
don't see in your pleadings.
Sir, he's also told me several times that he wants to live with me and that he does not want to live in
That does
Tawana.
not, that, the courts will tell you all day long that an 8-year-old does not get that preference. They just don't. I mean, everybody who comes in here says the kid wants to live with me. Kid wants to live with me. Kid wants to live with me. That does not form a proper cause or change of circumstance. There are certain legal avenues that you have to go through. You might not know them because you're
But
not.
what do I need to
and you
do
did
in
not
order to do that?
employ one. So I'm just telling you, that's what it is.
Okay, so what do I need to do in order to?
I can't tell you, I can't give anybody advice, because then why wouldn't I tell her, in order, if he does, I tell him to do this, ma'am, you go do that, and stop it, all right? The only thing I'm concerned with right now, because ma'am, you're going to be denying him apparently come school that extra overnight that he should be getting on Thursday. What are your plans for help making that up?
I'm currently in Tawas. I don't have Landon at the moment. He's with his father. The plan is to move back to Grand Rapids. This is not a permanent stay. Some unforeseen circumstances have come up, so I am planning on moving back down to Grand Rapids.
When?
I'm looking before Landon starts school in late August.
All right, where was he enrolled in school before?
He goes to St. Robert's Catholic School.
Okay, and is he gonna be re-enrolled there?
Yes.
And that seems to bring everything to a conclusion, even, sir, if I were to find any proper cause, she's gonna correct the thing and she's gonna correct it and move back to Grand Rapids. You'll get your parenting time and everything.
If that happens.
Man,
Okay, well, I wasn't sure that she was gonna move back. I didn't know if she was kind of just saying that. She
She just told me
hasn't
on the
always
record,
been-
if she just lied to me, that
I
wouldn't.
understand, sir.
I'm telling you, man, that wouldn't be wouldn't be good for you if you're just lying to me. All right. You will come back and I'll take your word for it. If he comes back and says something different, if you don't move back, I don't know, you can renew your motion. I'm not sure that custody had changed, but we certainly would have to do something with parenting time, because I'm not going to take parenting time away from him because you moved. Okay. You got that?
Yes.
You understand, sir?
Yes.
I'm going to deny your motion at this point because I don't think it meets Vidvarka. And we'll hope that we get back on track by the time school starts.
Okay.
All right.
Thank you, sir.
Good luck, everybody. Thank you. We're adjourned.
George Krupp for Chris Krupp.
Do recognize you, Mr. Krupp. How are you today?
Hi.
This is a matter of Kirby versus Kirby. We have both parties present.
I suppose if the defendant objects, we'll have to set it for an evidentiary hearing.
Yep. Mr. Kirby? Are you there? Mr. Kirby? Can you
Yes,
hear
Your
me?
Honor.
All right. All right. This is a request to move to Wisconsin. Husband wants to move there for a better job or more pay or whatever. They've asked to be allowed to move there. You have joint legal custody, I believe. So in order for them to do that, they would have to have a hearing if you object to them move.
At this point in time, Your Honor, I do object. I was just
All right.
made aware of this. I haven't been served, and I'd like to have legal counsel on site. He was served, Your Honor, twice.
We're going to set up an evidentiary hearing, a Lombardo hearing, to determine if the children will be allowed to move to Wisconsin. I would suggest that you get an attorney now. We'll send out the notice to you and be prepared to fight the change of custody. That's all I can do. I can't
Yes, Your Honor.
enter, and so you'll be sent a notice.
Judge, could you make note that we're going to be on vacation from August 3 to August 14?
Yeah, all right, we will. August 3 to August 14. It'll be set somewhere after that.
Thank you, Judge.
Good luck, everyone. Thank you. We're adjourned.
Thank you.
Thank you.
Number 9? Number 9. Are you sure? Number 9? Should we call it? Number 9 did not adjourn. Number 9 was Hood.
Yeah.
I already heard it, but number 9 is taken care of. Yes, it's the matter of Fuentes Alfaro versus Dalsami. Both parties are present via Zoom. This is the plaintiff mother's parenting time request. There was a judgment of support back from April 28 of 2022. Doesn't really deal with child parenting time. Have you been exercised? Mr. Dalsami, did you get this motion? I'm sure you did, because you're here.
Correct, yeah, Ms. Fuentes sent it over via mail.
All right, and you're asking, ma'am, that he get every other weekend?
Yeah.
What's he exercising now?
Kind of like when he's available with work.
All right, because you've made a request. Sir, what's, she's offering you to get every other weekend, Friday at 6 to Sunday at 6. Sounds pretty reasonable, because we need to set up something other than just what you guys agree on. I have to set up something specific, if nothing else. Yes, no?
As of right now, Saturdays and Sundays would not work for me just because I do work both of those days. I tried to explain to her that Wednesdays or Thursdays would work throughout the week, temporarily. It just wasn't a go, I guess.
Well, that's not going to work out too good, because the child's probably in school.
Yeah, in the summertime for now. Once we transition into the September fall time, I'm sure we will be able to change the schedule as well.
Ma'am, he is off for what is it, Tuesday, Wednesday, or Wednesday, Thursday?
Wednesday night and Thursday night, possibly even Friday night some weeks.
Well, what she's asking for, and I don't blame her, is something that's kind of certain, so that it's not always, you call and she's got to figure stuff out and this kind of stuff. Ma'am, do you work also?
Yes.
All right. Have the child leave, please.
Mommy, go over there. Go to the room. I told you. Go.
All right. So if I ordered that you had Tuesday through Thursday morning, what time do you go to work? What
are you asking me, sir?
Yeah.
Okay, so my schedule's a bit weird, but those days I have off towards the evening area, or the evening time, excuse me. Saturday, I just wouldn't be able to do it. So
I understand. I'm gonna make this as nice as I can, but at some time starting September, that may have to change. You said your schedule will change, but ma'am, do you have a problem for right now that he has Tuesday and Wednesday overnight? Not
No.
other times. All right. So what time can you pick up the child on Tuesday, sir?
It would have to be Wednesday, sir, and I usually get out at about 7 p.m., 8 p.m.
8 o'clock at night on Wednesdays?
Correct, yes.
And you can go pick her up at that time?
Yeah, it would have to be directly after work.
How far do you live from where she is?
Less than 20 minutes, maybe 15.
Ma'am, I know it's getting pretty late for a 5-year-old. If I were to have him pick up by no later than 8:30 on Wednesday and return, what time on Friday?
Friday we could do 5 o'clock, 6 o'clock. That works.
That'd be all right from now through the 1st of September. All right. So Wednesday at 8 to Friday at what time did you say? 5 o'clock?
Correct. There we go.
5 p.m. Do you want that every other week, ma'am, or through the summer? Is it all right every week, or what?
That's up to him. It's fine with me either or, as long as it's just like the set date and set time.
All right. Well, we can continue that indefinitely, because he can get her to school also on that Thursday and Friday.
Okay. Every other fine then.
Every other. Sir, every other Wednesday at 8 o'clock until Friday at 5 p.m. That's the continuing schedule right now. It'll be every other week. When do you want to start it? Do you want to start it this coming week because you got enough time to get all set up?
Yeah, that works. Around the fall time, I will be moving out of the city there, so it may not be able to continue throughout the fall.
Well, so you're just gonna, what do you want? Your child doesn't get to see you? You're not gonna see your child?
No, from at that point, we could possibly do the weekends. This is why I say just depending on the
Well,
schedule.
all right, but let's leave it at this right now. And ma'am, if he gets a chance and is not working on those days, I would most likely change it to Friday at, 6 o'clock till Sunday at 6 o'clock, every other weekend. But for right now, we're gonna leave it at Wednesday, because I don't know when you're gonna be working, sir. So it starts this Wednesday at 8 PM to Friday at 5 PM. You can pick him up. You can pick up the child at the mother's house and drop off at the mother's house right now. If there are further changes needed, somebody can renotice this motion. You know what I'm trying to do. And I'm trying to make it so that she has some certainty too. So does your child have some certainty. You should know when you're gonna visit the father. The second motion then also relates to child support. Ma'am, you say you want child support calculated by the friend of the court. It was calculated by the prosecutor's office less than 2 years ago. What's the change that's happened since then?
I know my pay changed, as well as I know he was considered part-time at the time as well. So I don't know if that's true or not.
Is that true, sir? Your calculations were, you were working part-time 2 years ago?
At the time we were, but the amount that we discussed there, it was a mutual agreement amongst 3 parties involved.
Mutual agreement, you mean the prosecutor's office?
Correct. Her, myself.
Yeah, well, that's
and the
fine, but if it was
prosecutor.
based off of part-time, employment, or what your income was, maybe that's significantly changed. Has your income gone up or down, ma'am?
I believe it went up.
All right, yours doesn't count though very much. Sir, you're obviously earning more than you did 2 years ago.
Are you asking me, sir?
Yes.
Okay, yeah. So for the summertime, now it is a full-time schedule. And then once I return, I do also go to school. So I work a number of jobs there. So as an undergraduate research assistant, work on the executive board and other small tasks.
The only thing I'm gonna do is send it to the FOC for child support. I have no idea what that'll mean. It could mean more, it could mean less. I don't know. It's been 2 years. Normally we wait for 3, but because of the changes and stuff that, I'll just refer it. It doesn't cost anything for you. So I'll send it there, and you'll both be notified. You gotta cooperate, or the friend of the court will do their own calculation, and neither of you may like that. All right, so they'll just notify it. All I want to do is get the correct amount. It's not, has to do with anything else. It's just the child support per the state guidelines. So I'll send it for there. I'll also get out the order. It will start this Wednesday, sir, 8 PM to Friday at 8 PM. All right.
Copy.
And if you need a change, you can renotice. Well, ma'am, you could renotice this motion, and unless you guys can agree on it. If you can agree on it, come to the Legal Assistance Center. They'll help you draft a stipulation and order regarding parenting time, so that it goes now from Friday at 6 till Sunday at 6. You can enter that. You can both sign it and give it to me, and you don't have to come back. All right? Good luck.
I did have another question, sorry. In regards to communication with the child, like when they're at their dad's house, is there a way to put that I do have the right to do that?
Well, sir, the child's only gone for a short period of time, but I'm not gonna enter anything in the order, but sir, be reasonable if she want, and you have to be reasonable too, ma'am. This is his time, his child. If you wanna call once, it's no big deal, but if you start calling every, hour or 2 hours, let him be father, okay? You can tell your child, Alexia, he's the father, okay? You'll be fine with him, and if you really think certainly you would call him if there's some kind of an emergency, but, just both of you be reasonable. I assume you will, won't you, sir?
Yeah, that's correct, sir. I'd like to say I'm pretty reasonable.
Well, I hope so, and let's hope this all works out, all right? I mean, if she calls once or something and says, hey, can I talk to Alexia? And you say, sure, no problem. But don't monopolize her time. Let her spend time with dad, okay? Just like if he calls the daughter at some time when you've got and stuff like that, let him talk, but as long as it's not unreasonable. Let's start setting up the child's gonna learn from how this works between the two of you, all right?
Perfect.
And she's gotta have two good parents who, you don't have to like each other, but you have to get along for the child's sake, all right? Be reasonable with both of you. Good luck, we're adjourned, thank you.
Thank you.
79 DM, both parties, Mr. Jeltman and Ms. Miedema are present on Zoom regarding a couple of kids, 16 and 10. This is the mother, the defense, wait a minute. This is your objection, ma'am, to the friend of the court report and recommendation, correct?
Correct.
Well, we can't enter the order, sir, that is submitted by them because there was an objection filed. My real question to you, ma'am, is you filed an objection back on 3/21/24. Why is it, why are we having a hearing in middle of July? Why'd you set it for this far out?
Well, I just picked something that I knew that I would be able to go to. Work has been really hectic.
This just delays this forever, okay? And it's kind of your delay on it, so, all right, I can't enter the order. Objection was filed in a timely manner. We have to set an evidentiary hearing regarding the parenting time, and we will do that and send it to both of you. Anything you wish to say, Mr. Jeltema? I can't enter the order of parenting time, and I can't do anything because she filed an objection. I'm bothered by that it's 4 months out, but because you've lost 4 months, but you understand, sir? Anything?
Yes, I
you
do,
wish to
sir.
say? Pardon?
Yes, I do, Your Honor.
All right, well, we have a good address for you. Don't tell me what it is because we're on YouTube. But we have a good address for you, and let me just say, is it 3389?
Yes.
All right.
Your Honor.
You'll get notice of the hearing regarding parenting time. If you both come in without attorneys, you're foolish because you don't know what, it's gonna be a formal hearing where you gotta introduce evidence according to the court rules and all that kind of stuff. I'd get attorneys if I were you, but can't force you to. We'll set a hearing. Thank you both very much. Have a good afternoon.
Thank you, Your Honor.
Thank you.
Thank you.
4DM, Kent v. Kent. Mr. Block, I'll state Mr. Block is present for Mr. Kent. Miss Kent has never logged on. Can you assure me of proper service in this matter, Mr. Block?
I would have to refer to my client, but he advised me, well, tell the referee.
We dropped it off right at the downtown Grand Rapids post office.
A copy of this motion.
A copy of this motion with the address that I was last provided, that I last knew that her mail went to.
And have you received it back?
I have not received it back.
When did you drop it off at the post office?
The same day that I filed it, which
Okay,
was the
you have
first.
listed here as 7/1.
Yes, that's the day that I sent it in the mail.
All right, then, let me just make sure here. July 1 is a week ago last Monday. If you had appropriate stamps on it and everything and dropped it off, right?
Yes, it was right at the post office downtown
All right.
Grand Rapids.
And I'm assuming that the only address that you have is the 3695. I'm not gonna ask you any more about it, but 3695 address, is that correct?
Right, that's the only one that I have.
And you've yet to have it returned to you?
I have not had it returned, no.
All right, have you had any conversation? I mean, you got a kid together.
I've told her that I was filing a motion to be heard because of her being at that
I
gentleman's
understand.
house.
You've had a conversation with her since then? Since September 1 or since July 1?
No, the last time she contacted me was yesterday, is just saying how are the boys?
Oh, you have the kids right now?
Yeah,
How long have you had them?
since the June 9th, or what day was that? When she decided to say that she didn't want to have kids no more, it was June 7th is the last time she had them.
That's the last time she saw them?
She saw them on the 30th, but the last time that she had them for her full week, she dropped them back off to me on June 9th and said that it's in the best interest that the kids are with you full time.
All right, Mr. Block, I'll be interested in hearing from you because quite frankly, I read what your client put in. I know he sent in pictures of her being at the residence apparently of the, and I mean, I got the picture. I don't really know whose residence it is, but I'm assuming your client's not lying to me that that's where this prohibited person lives. I know he put in his motion that said, you know, she said she was at that house because the sister lives there. And she can be any place she wants as long as Mr. Wood isn't around. And so.
But what is particularly troubling was that the 8-year-old boy that was there said that the sex offender had been there while he was there that weekend of June 30th. So I mean yes, it's an 8-year-old's statement, but
you know how the court is not supposed to take many of those statements into consideration at this point.
Yeah,
under what
I do.
circumstances it's coerced or whatever. I'm not saying he did, but you also know that the court is very reluctant to take those statements.
Yeah, no, and I get that. However, this Robert Wood was registered at that address.
He is registered at that address?
Yes.
Well, I mean, her not being here also speaks volumes to me.
Agreed.
As far as what's going on.
And my client really doesn't want to suspend her parenting time, Referee Frederick. I mean, he wants, these kids to see their mom, but she's got to behave.
Well,
he was.
Yeah, and I got a question. I mean, I appreciate your clients trying to get the child to see his mom. All right, I do, and that you're going out of your way, and then factor J of the child custody factors, willingness to an ability to work with the other to try and get the other person there. He meets that so far beyond what most people would do. Yeah. I understand that, but I don't understand what you want me to do with this. Well, I can say, don't do that again, but that's like, she is prohibited from having that kid around, right? Yeah. And I didn't. That isn't an advice. That is an order.
Yeah. And I guess short of a video of this prohibited person going in and out of the camper, it is difficult to
I'm kind of inclined to believe that she has violated that order. All right, because it is his residence. She even says it's his sister's and stuff like that. If she wasn't there and things, I don't know why she wouldn't be here to say, wait a minute, that isn't where he lives or something like that. And I am concerned. I am concerned, and I issued an order specifically not to be around that person. And from a preponderance of the evidence, I think she probably violated that order. From a contempt, I don't know, but this isn't a contempt hearing. I guess what I'm really asking is, what relief do you want?
Well, and I talked to Mr. Kent about that because he didn't put any in his motion, if you noticed.
Yeah, I noticed.
I said, well, Jack, Kent, what do you really want? And I think what would maybe be good would be some type of like a supervised parenting time, or maybe she just has the children on Saturday for a while, but not overnights, and can't go to that address. I'm kind of at a loss here. Maybe make it supervised with a responsible adult every other Saturday.
Yeah, but I would ask then, who do you want to supervise? Because if I say a responsible adult and she says it's Wood's sister, all right, and we're going there, all right. How do I mean, my thought is right now is that either she gets only a Saturday time from 10 till 3. I guess this possible harm probably from 10 till 3, and I don't know if you want every Saturday or every other Saturday, or I was prepared if I had the real feeling that Mr. Wood was around to send 2 journeys for supervised parenting time, but that costs, and I don't know that the parties really need to do that. All right, so I guess I'm
sorry.
No, that's all right. I'm asking you, what do you want?
Yeah, I think every other Saturday from 10 to 3 would be a good idea. She has not been exercising even the time that she has. So I'm thinking every Saturday from like 10 to 3.
Every Saturday or every other?
Every other.
So is that, I mean, your attorney speaks for you, and I normally just listen to him, but you're sitting there and you're working. Is that what you'd like?
That's what I would like, your honor. I don't want to suspend it, but if it comes down to that, then I don't know what else to do besides giving her this opportunity to make things right with their children.
All right. We'll start it next week, Saturday. Okay, not this week, because we wouldn't even get information to her fast enough.
Yeah.
All right, so we will do every other Saturday from 10 a.m. to 3 p.m. until further order of the court.
One other housekeeping matter. I'm gonna put back in there that Robert Woods is not to be around the children. I know there's already an order that says that, but
There
is it
is.
okay if I add that back in?
There is, that's fine.
All right. One housekeeping matter, which I don't know if you want to take up now or not. On the 28th of June, the parties signed a stipulated order about custody, which I think then obviates the need for this evidentiary hearing in September 9th. Because there was supposed to be a Bud Barca hearing on the 9th.
Yeah, have the parties submitted the order to me?
Yes, and I believe it was, let me look. I believe it was signed. Stipulation and order for custody and parenting time was signed on June 28th.
And it says what?
About joint legal custody, parenting time 3 weekends a month, from Friday at 6 till Sunday at 6. Holiday parenting time, and 2 1-week periods during the summer.
However, I'm modifying that parenting time with this.
Yeah, and physical custody with plaintiff.
All right. Well, I mean, if it was a threshold hearing, and now it's subsequent to that, they have stipulated a custody, that hearing is not necessary.
I would agree. So I just wanted to point that out so you could, free up your docket, so to
Yes,
speak.
thank you very much, because we'd be waiting, and then at the last minute, you'd be going, are they at a hearing? And I'd be going, well, I'd be saying some things that I can't say on the record. Okay.
Yeah, so that I don't think I don't know how we cancel the 9th, whether there's a notice.
Well, my clerk will be happy, and she's smiling, and then she will cancel the 9th hearing at this point, because the custody issue subsequent to me issuing that order has been handled. Now,
Yes.
parenting time, as a result, I'm changing it to what they agreed to because it's inappropriate. All right.
Yeah. Yeah.
Yeah, and yes, you can put in there. There was nothing in there about Mr. Wood in the custody order.
I don't believe so. But it did have the paragraph, any and all prior orders and terms not changed remain in full effect.
I want you to put in your order then matter about Mr. Wood.
Yeah, I certainly will.
All right. I think that takes care of it.
Very much. Thank you for your
And
patience.
the hearing's off, and thank you for telling us in advance.
You bet.
Thank you. Have a good day.
Yeah,
Cranky
thank you.
versus Redmond, both are present via Zoom. This is a motion filed by the mother. It's basically an objection to a friend of the court report and recommendation that was submitted by the friend of the court after a referral to the friend of the court by Judge, I believe Judge Hillary referred it for physical, legal, parenting time, and child support. That was on May 3, 2028. There was also an order of reference that was sent out, the result of prior hearing that referred it to Journeys for parenting time, things like that. And there was a order the way it was supposed to go. He was going to Journeys for a while, and then unsupervised on Wednesdays and Thursdays. But all that is kind of superfluous. Basically, you object to the custody recommendations, parenting time is likely.
Yes, sir.
Friend of the court.
Yes, sir.
It comes down to this. I can't enter an order that is recommended by the Kent County friend of the court. I cannot enter it if there's an objection. I have to have a hearing on it then, or parenting time, child support, everything. Because you're objecting to everything in there. Is that correct, ma'am?
Yes.
So I have to have an evidentiary hearing for all these issues. Here, I'll give you a chance to say something, but I can't do anything else. You understand?
I understand. And I feel like
Hold on, Mr. Redmond, you understand?
Yes. Yeah.
All right. I mean, I just have to have an evidentiary hearing on physical and legal custody, parenting time and child support. And all I can do is have that. I'll send out notices to you as soon as I can. You'll get a notice. I hope I have a good address for both of you. Don't say it because we're on Zoom and I don't want your address out there. But I'm assuming both of you have confidential addresses. We can get it out to both of you as soon as we can. I'm gonna warn both of you that if you show up with no attorneys, you're gonna be at a huge disadvantage, especially if the other person does. I can't have an informal hearing. I can't have a hearing that's, you know, like you guys just, we talk this and, you know, you say, well, John told me this and that. I gotta follow the rules of evidence. It's a formal hearing. You'll call witnesses. You'll have to, if you present evidence, it'll have to be, you'll get things in the notice that says how you have to exchange it ahead of time and all that kind of stuff. You have to follow this. Failing to do that, may result in you're not being able to put evidence in or whatnot. All right, so I'm asking you to seek counsel because, and counsel may be even able to work stuff out, but without that, you're gonna be at a disadvantage. You will be sent notice. It'll be a, you know, a couple months out or so because we've got so many hearings scheduled, but you'll both get it. And then we'll come in and we'll have an evidentiary hearing and I'll have to make the decision. All right, you understand that, Mr. Redmond? All right, thumbs up. Ma'am, you
Yes.
understand that?
Yes, sir.
All right. You'll get notices. All right, good luck. Thank you both very much.
Thank you.
Have a good day. DS, Simon versus Denny. Ms. Simon is here who filed the motion for custody. Mr. Denny is not present. We were set for, and the motion was filed for 8:30. Did you inform them of a later time or something?
No, he got the paper and it was all on the paper, so.
I'm
He also-
asking my clerk something, all right?
Oh, gotcha. Sorry.
No, I didn't have an email, so as far as.
All right, so this was set for 8:30 today. He has never logged in. And to Zoom, he has not been present in the courtroom either. You have stated that you served him by hand on July 4?
Yep, his mother did.
What do you mean his mother did?
I told the clerk that his mother would be serving him the papers when I filed them.
But how do you know his mother served them?
I'm good friends with his mom. She gets my daughter a lot.
I understand, but that's
No,
not the question.
He informed me and he's also messaged me about it. So he knew that we had court.
When did he inform you and all that kind of stuff? Can you sit down kind of?
Yeah, sorry.
When did you talk to him about this?
He messaged last night about court.
What did he say?
He said, so we have court in the morning, and I agreed with him. So.
And so, I mean, because here's one of the problems. You have signed that he had service by hand on 7/4.
Yes.
But you didn't hand it to him.
No, his mother did.
You gotta be more careful about service, I'm telling you. I'm not really sure. Service is proper in certain ways and did she tell you on the 4th that she served him the papers?
Yes, I have text message
right.
text messages from her that she had served him.
All
and that
right,
he
and
wasn't
he
happy
clearly
about
knows
it.
about it because you talked to him last night and he still hasn't appeared. He has not appeared at any time.
He also messaged this morning about it.
And said what?
It's on my messages. He said, and thanks for the heads up for court.
Well, he never logged in, so it appears that it's been over 2 hours since he should have. This
Yes.
is the plaintiff's mother's motion regarding custody. There's joint legal and physical custody according to a stipulated order back in 2019.
Yes, we had,
At that point, I did see a uniform child support order that showed that at least that order said they had 50-50. Mom now says that the child spends basically all the time with the mother, which would be a change of circumstance if it's changed from 50-50 to, 98-2. She says the father has recently been evicted. Do you know where he lives?
Nope. I believe he lives out in Lowell with his other child's mother. I don't know the address to where they are though. I could only bring you there.
Well, you're not gonna bring me there, I can tell you that right now. Okay? Uh, I know there's a lot of stuff in here that you talk about who pays for what and stuff. That doesn't come into play. I'm just warning you in custody.
Okay, I was only going by the papers that they gave me.
But
That's
does-
how I wrote it up.
So, I mean, factor 3 in the child custody factors does talk about ability or whatever, but however, so it's your statement, how long ago was it that your daughter used to go back and forth 50-50?
So it probably only lasted about a year. But I really didn't get anything from the court. And I think he was only paying like $20 for medical, for Medicaid or whatnot. So
What do
it's
you
actually
mean?
it's been a few years that he hasn't actually, sir.
Since the order in 2019 for
Yes.
legal and physical custody, has it
Yes.
changed to the point where you now have the child most of the time?
Yes, because then he turned to getting her maybe once a week and then every weekend for a few years. And that was fine with me. But then since the beginning of the year, he's kind of been like scattered around and not seeing her.
All right, well, since the stipulated order back in 2019 gives joint legal and physical, even though the stipulation says both parties have joint legal and physical, it doesn't really say who has what, when, where, just joint legal and physical. Parenting time, both parties have specific parenting time according to a parenting time schedule as follows, but there is none. Child support, uniform child support order. That order from May 3, 2019, and I'm only taking it in conjunction with the UCSO, the child support order that gives 182.5 to each. Change in circumstance certainly isn't new, but there is a change of circumstance or proper cause to enable the court to have an evidentiary hearing regarding custody, physical custody of the child. We'll set that up. That's all I can do today. I can't change custody on a Friday morning. It has to be through an evidentiary hearing. Let me warn you, you're gonna come in on an evidentiary hearing, which is a formal hearing. You gotta introduce evidence and documents and things like that. We'll send you an order as to what is expected as to exchange of documents and things like that. And trial briefs and things, you're at a real disadvantage, and he is at a real disadvantage if you don't have some type of attorney representing you, because I can't help you at a hearing. I just I want you to know that, okay? If you bring stuff and you say, here, I want this in, you gotta know how to introduce it in evidence. I can't tell you what you gotta do because it's unfair, okay?
Okay.
So if I were you, I would, and possibly if you had an attorney, maybe you could work something out and get this taken care of the way it should. Or maybe even talk to him and you can enter another stipulation and order, okay? If you guys can agree on stuff, but we'll send you out notice of the hearing. I'm not gonna ask you your address because we're on Zoom or on YouTube, but is it still 5364?
Yes.
All right, then we'll get that out to you. It's gonna be a couple months till there's an actual hearing on it, but you'll get notice. Please follow what is on that notice, all right?
Thank you. I'll get it with the lawyer. Thank you.
Good luck. Thank you very much. Have a good afternoon.
You as well.
12411. Both parties are present. Ms. Kucharski via Zoom. Mr. Rademacher is here in the courtroom. Ms. Kucharski is represented by Mr. Sherlin, who's also present on Zoom. This is the defendant's motion to set aside the default that was entered in this case. Mr. Sherlin will start with just the default, okay? Not the hearing regarding custody and stuff. We're just starting with that. And I'll tell you honestly, I mean, there's so much here in the file that indicates that Mr. Rademacher went through everything appropriate to serve her, that I just don't buy it that she wasn't served. She may not have got the documents, but it is a process server. Again, if it was Mr. Rademacher saying his friend did this stuff, I'd question it more. But there's many statements from the process server that resulted ultimately in alternate service. And I think there's a picture in here of it being taped to the door, and there time after time, unsuccessful attempt, unsuccessful. I received voicemail from the defendant, unsuccessful. There's one in here that talks about that there was somebody at the house, but they didn't, when he got there, they just walked away and refused to answer the door. My only question to you, Mr. Sherlin, is, and I'm not gonna read the whole address, but 11877 is where she has resided, is my understanding.
Your Honor, my client can confirm if those are the correct.
That where you live,
street
ma'am?
numbers.
Yes, Your Honor.
All right. I mean, I really just, I don't find any amount of evidence to show that, I just think she didn't pick it up. She didn't want to be served and she wasn't served. So I'm inclined to not set aside the default. We'll go on to the second issue, which is your main issue, I think, anyhow. But if you want to say something about the default, I will, but boy, I got a bunch of stuff in the file here, if you've had a chance to look at it, that just shows repeated attempts and the judge's alternate service and even a second alternate service to do that. They did everything possible to serve your client.
Your Honor, I noted in my motion that there are these strange gaps in time in the Register of Actions as well. There's the Register of Actions shows there's months that go by before action is recorded regarding return of service, that type of thing. And I think the motion for alternate service included posting and serving a member of the household. And I couldn't tell, I understand that the proof of service claims that it was posted, but I couldn't tell if there was actual service of another member of the household. And that would be inconsistent with what I think is consistently said by the process server, that they couldn't get a hold of anybody. So I'm not sure service occurred.
But the process server is only as good as somebody who will answer the doggone door. All right. I got a picture here of it being posted. Now I don't have anything. I guess he could have posted it on his neighbors and just taken a picture of it, but this is a process server. Okay. And I don't believe he is, I mean, that's his job. He'd lose his job if he hadn't done this. And I don't believe that that's.
Well, Your Honor, if I may though, I find that I've been very choosy about the process servers that I use. And when I find one, I stick with one because I find a lot of the process servers employ people part-time. They get paid 10 or 15 bucks for making the service. And it tends to be a fairly casual. Now, I don't know if that's this person or not, but I guess I haven't seen the picture, but using your comments from a prior hearing, was it taped on with duct tape or was it a piece of Scotch tape? You know what I'm saying?
I would say it was, what do you call the other? There's in between. It's masking tape from the look of it.
Well, if it's painter's tape.
I know, but Mr. Sherlin, you understand that. I mean, we can only do so much. I can tell you at one point, this process server, Jerry Gross Jr., Michigan process server, on 3/27 states successful attempt 3/20/24 at 6:01 p.m. That it just says successful attempt on 3/20, and that was the first one that was successful on 3/20/24. There is a note down here, 55 plus, ethnicity, Caucasian, gender. A male was in the kitchen, was at the kitchen table when I knocked. He stood up, looked out at me, and disappeared into the house. Nobody would come answer the door, as with all of my previous attempts. So drop service was performed. I'm sorry, but I just find that, I don't know, she can avoid service forever and just nobody can answer the door every time they go there. And there is something tacked to the door. And unless you can show me something that the process server is not reliable, I'm inclined to leave it. All right.
Well, Your Honor, I can address that. First of all, the ultimate resolution would be publication, right? You can't avoid publication. But regardless, Your Honor, I think you hit on, your last statement hit on exactly what my proposal would be. I think when we get to the second part of the argument, it's pretty clear that we need an evidentiary hearing.
I understand that. Okay.
So could we reserve on whether the default is set aside or not, probably isn't the biggest issue here.
That's right. That's why I said I know your second part is more important.
Right. So all I would ask the court to do though is, if we're going to have an evidentiary hearing, just to procedurally close, because I have a very different story from my client. You know, I don't know. I wasn't there. You weren't there. So, at a minimum, if we just reserve the issue of the default itself, the process server can come in and tell the court what was done and what was not done, and I can ask questions. It's no harm, no foul if we're going to run an evidentiary hearing regardless.
But it makes a big difference because I'm going to tell you, Mr. Rademacher, you're here and you can say something in a minute. All right. But no matter what, obviously the order, the default order that is presented to me is, I got to have a hearing on custody, especially when Mr. Rademacher, it's clear even in your statements that you haven't seen the child since last year or maybe longer. And you give yourself full legal, physical, you only allow one weekend at your discretion for parenting time, which is the same as saying she gets nothing. Mother's Day and Father's Day, you got that checked. What? I know, but that's not, that's, and Christmas Eve and this kind of stuff. That's not an order that I can take at this point without additional information. Parents will meet at, Kent County Sheriff's Department. She has to continue seeking program, mental and physical and substance abuse. I don't even know if it's appropriate. Parenting time should not interfere with extracurricular activities. Well, she doesn't get any in your in the one that you're proposing to enter. The court does have to find not just establish custodial environment, but the best interest of the child is what the child. So Mr. Sherlin, this is what I guess I'm finding at this point. All right. I believe service was appropriate. I don't believe we should set aside the default, which puts you behind the 8 ball, because at this point, she would be allowed to cross-examine other witnesses and call her, you could call her as a witness. All right, that's something you can do in the custody hearing. However, I'm going to leave it open that if you think there are other things that are appropriate and necessary, you can file a motion and I can consider those. I'm not saying that is the end. All right, I am saying that if you think we got to bring in such and such and such and such, and you have reason for it, you can file a motion and I can look at it. All right.
Well, Your Honor, if I may, the court rule says specifically that she could even participate. It doesn't put that limit on the hearing, and it even allows her to participate in discovery if the court is so inclined. I'm not asking for
the court is so
discovery.
inclined, okay?
Well, but the court has to be fully informed in terms of the best interest of the children.
But I'm not going to say that she gets defaulted and then just everything goes back to normal. I'm leaving it open for you, okay? You can, if you might be able to say, hey, I need discovery with this, this, and this. Would the court allow that? All right. I'm not precluding it. That's what it is. The court can, and I haven't said absolutely no way. Right? That's different than saying that. All right. Because it's up to the court, even as you're just quoting the court rule, the court may allow that stuff. Okay.
I get that the court may allow it, but it also says the court has to do a complete inquiry.
Well,
and if you're going to do a complete inquiry, I have to be able to give you my client's side of things.
I'm just telling you that it puts a little bit more burden on you.
Well, I get that. I understand that, which is why I'm still concerned about the quality of service here. I get the court's read of the file, but if you want to
schedule a half-hour hearing to call the process server in, because quite frankly, I'm not going to buy much what your client says about I didn't get it. I'm only going to buy what the process server says as far as an attempt. All right, because everything in the court, Judge Hillary looked through that and ordered alternate service. All right, he didn't order alternate service if nobody made an attempt to begin with, and he doesn't believe it. All right, so you're kind of up against that, and I believe he ordered a second alternate service, like through email or something like that. There was a second. I mean, I think.
Well, I recognize that, Your Honor, but it's also done ex parte, so my client's side wasn't heard.
I understand, but I know you're not really challenging Judge Hillary's ability to review.
No. I'm not arguing the procedure here. I'm arguing the substance. And
Are you saying you want a half hour or at most an hour? Because we can put something in relatively soon and try and get the process server here. But I'm telling you that if there's costs involved with it, it's going to be all your costs. And if Mr. Rademacher chooses to get an attorney to represent him, it's all going to be your costs unless you can prove that, you know, the whole thing was incorrect. If you say, well, the process server said he never tried it and all this kind of stuff, and then it's obvious it should be set aside, I'm not going to charge you for that. But if I find that the service was attempted in an appropriate way and stuff like that, it's going to be your cost, including that hearing.
Well, that sounds like loser pays.
It sounds like, to a certain extent, it certainly is. If you lose, you will pay. All right.
I'm not sure
you will do whatever you want regarding if.
All right. I respectfully, Your Honor, I'm not sure that's the law in Michigan, but okay.
Well, I'm just warning you that I think everything is appropriate, and you're questioning this, and I'm giving you that opportunity if you want it. But you normally to set aside a default anyhow, if he had expenses involved with it and
Right.
it doesn't get us, you know, you have to pay X number of dollars to have it set aside, all the expenses it cost him. All right.
I recognize that. I recognize that there can be costs ordered as part of
That's
setting
what it
aside
would
the
be,
default.
would be costs, would be ordered. All
Well,
right.
here's what I'm getting at, Your Honor. I don't know that that's necessary if my client's able to present an accurate and complete version of her side of the facts.
That's up to you filing and asking me. I'm not giving her anything
Okay.
right now other than her ability to participate. All right. Meaning she can testify, you can cross-examine, all that kind of stuff. If you think there's other stuff and you can show that it's clearly necessary, it's most likely that I'm going to allow you some of that stuff.
Okay. All right. Well,
I'm not saying right now I'm
propose-
allowing it, but I'm telling you ground rules right now as we leave is she can testify and she can cross-examine.
Sure. Well, Your Honor, I think it would require an in-camera interview as well. You know, we need to do all of that stuff.
What do you mean in-camera interview? Obviously I have to follow the child's best interest, one of which is the preference.
Right. Yeah. So I think the children.
I mean, that's
Right.
part of it. That isn't.
Okay. I just want to make sure that you know, we're following all of that. But why don't we do this?
You're going to be lucky to do that. Are you trying to say? All right.
I'm sorry, Your Honor, I didn't hear you.
I said you're trying to say you want to make sure I know what I'm doing?
No, of course not. Of course not. I'm just trying to understand the limits you're putting on it. That's all.
Limits are pretty straightforward right now. All right?
Okay. Well, why don't we do this then? With the court's permission, we'll hold off on the half-hour hearing with the process server until I get a feel for the scope of my client's presentation. I'm going to have to consult with her, see what the witnesses look like, that type of thing. And I'll file that motion regarding the scope of the hearing. But, you know, obviously what I want to clarify is if the court finds there's an established custodial environment with my client, then and the children have been residing, I think Mr. Rademacher admits the children have been residing with my client exclusively since at least last year, that it'll be a clear and convincing burden for Mr. Rademacher to meet to change that established custodial environment. But I guess I can hash that out in the motion.
I'm not giving any advice on anything because he's probably saying she's keeping the child from him, which I understand may not even, I mean, an established custodial, this is not my first one. I understand the established custodial environment is created regardless.
Right.
But you got to understand what the limits are, and that she has to pay some penalty for defaulting. All right.
Well, that's why the default issue is so important, but I'll take it a step at a time. I'm not trying to be difficult here by any means.
And I know you well enough to know you're being difficult because that's you.
Well, I just want my client to have a fair.
Now knows this also. All right. So
I just want my client to have a chance to show her
I have to
side.
have a hearing on custody, sir. I have to have a hearing on custody because I can't enter an order like that gives you everything and gives her absolutely nothing. And you, like I say, you have admitted that you haven't seen the child for I don't know how long, but since November 11, Mr. Sherlin, that's something you should also work on, quite frankly, if we're ever going to get to the bottom of this, of him not being able to see the child. However, you understand that's practical. That's not legal. All right.
Yep.
All right. So, I guess what I'm saying, Mr. Rademacher, if you get a chance, why don't you call Mr. Sherlin to see if you guys can start to work on anything? Is that appropriate, Mr. Sherlin?
Well, I'm always available and interested to talk.
Well,
Sure.
and because I don't think he should necessarily be talking to Ms. Kucharski, because it doesn't sound like they get along really well.
Well, there's been a PPO in the recent past.
Yeah.
But Your Honor, if the only caution I would throw out there is if Mr. Rademacher does engage or is in the process of engaging an attorney, I hope he understands that then I can't speak to him. I'll need to
Right.
speak to his attorney.
Right. And I'm going to tell him right now, it's foolish not to have an attorney because he is an attorney and this is a custody hearing and it's a formal hearing. All right. So you've heard me say this because you've been sitting here in the courtroom forever also. Okay. You are foolish not to engage. And if you do, he can't talk to you anymore.
I understand.
All right. So I am hopefully you do. Hopefully you get one soon and the attorneys can start hashing some of this stuff out. All right. Any questions that you have?
Well, I was here on that motion side, but I did purchase phones for my daughters that their mother is keeping. Not only I haven't seen them, but she's not allowing them to talk to me at all. So I don't know what type of alienation is going on. Is it possible that she can allow them to speak with me?
That's what you should talk to Mr. Sherlin about because he clearly, I mean, I can't make a ruling on that because it's not before me right now
Right,
and everything. So
Mr.
Mr. Sherlin has been doing this since, well, not quite Abe Lincoln, but because I was Abe Lincoln, all right? He's younger than me, but he's got a lot of experience at this. He also understands the realities and some of the things. He also understands some of the things that I would probably rule and things like that. So please engage an attorney to talk to Mr. Sherlin about it. That would be the very best. Okay. What? Yeah, I know, but we just lost her. You don't.
It's okay, Your Honor. I think she's seen the substance of it. We're fine.
So you understand that. Please get an attorney as soon as you can. If you don't, make sure you talk to Mr. Sherlin at least. And those are the things you'd bring up to him. Hey, I've got some phones. Could I have contact and this kind of stuff? And if he says no, he says no, but he might be able to talk to his client, whatever.
I do have a question. If I do choose to obtain counsel, she won't be responsible for paying when she loses.
Once you'll each pay for your own
Okay.
attorney.
I just don't want to put an unfair burden on.
No, it's each will pay for your own attorney. And I hope, I mean, you say if you choose to engage one, you are at a tremendous disadvantage if you don't.
I understand that.
Mr. Sherlin is a tried and true, long time he's done a lot of these things and I'm not gonna say on YouTube, but he's good at it. And so just be aware of that, okay?
I promise not to try very hard, Your Honor.
Yeah, I hear that. If you could, I guess if you would draft the order that says that I denied setting aside the default, but we will have an evidentiary hearing regarding custody, parenting time, child support. We will send out the notice to you, but I'd just like something in here that says what we did today.
Your Honor,
Very simple.
once I can consult with my client, I'll file that motion to define the scope of the hearing. But just a heads up, I'm going to be out a good part of next week for some personal reasons.
That's fine. That's fine.
I don't think I'll be able to get it on for the court's docket in 2 weeks. It'll probably be 4 weeks.
That's, you are not going to get a hearing in 2 weeks or 4 weeks. I can tell you that.
I'm also, I guess, saying that a little bit for Mr. Rademacher's benefit so that he understands the timing of it.
All right. And the order he's going to send through is just going to say that I denied to set aside the default and that we're going to set up an evidentiary hearing.
And Your Honor, I think actually Mr. Rademacher had renoticed his motion to enter the default judgment today. So can I include that entry of the default judgment at this point is denied?
Yeah, I'm not going to let you enter it. So that's fine. It makes the record clear. I'm not going to do that. I'm going to have a hearing. You moved to enter your default judgment. Yeah.
I renoticed my FOC 10 on your request.
Yeah, well, whatever it is, you're not going to get we're not going to enter a default custody order. We're going to have a hearing on custody. Okay. All right. All right. Good luck, everybody. Thank you.
Thank you, Your Honor. My apologies for being difficult this morning.
That's all right. I've grown to know and appreciate the difficulties. Did I say that?
Yeah, I did oh wait, recording's not allowed. I didn't record it, but I remember.
Thank goodness. Thank goodness. Take care. Have a good
All right.
weekend. Mr.
Thank you.
Rademacher, you sat here the whole morning and I appreciate it. Sorry we couldn't get to you sooner. Thank you.
Thank you.
Thank you, Your Honor. Thank you.
Oh, yeah, it's gonna, the notice of the hearing. Okay, good luck. Yes, you too, and an attorney, please. Parties are present. Ma'am, can you hear me?
Yes.
All right. And, oh, Mr. Cox did appear. I said it was nice seeing you while you weren't there.
Well,
But
it's always stressful for Mr. Swears because he's intimidated by my stunning good looks. So I know he's very nervous this morning. Very nervous.
I'll stipulate to that on the record.
Yeah, well, he has.
Yeah. Now you know why my wife wants me to give up my stand-up comedy career. So, and probably my client, right, Carrie?
Yeah.
All right. Thank you all for waiting. I know it's a long wait for you this morning. This is, as I say, Steele versus Steele. Both parties are present via Zoom, as are their respective attorneys. Mr. Cox representing the defendant, Miss Steele, and Mr. Swears representing the plaintiff, Mr. Steele. This is a motion that's filed by the defendant regarding enforcement of some of the provisions of the judgment of divorce. I've read both the filing and the answer filed by Mr. Swears. As I have kind of boiled it down, I think there are like 4 issues really that are present, that being the life insurance, family pictures, personal property, and the Verizon matter. Do you agree that that's primarily what I'm dealing with here?
Yes, Your Honor.
Mr. Swears, you agree also?
Generally, Your Honor, yes. However, I was thinking about it this morning, and the question I think I have, I spoke about the Verizon matter for some length, but when I rethought about it this morning, I think this is property acquired after the marriage, if I understand the timeline correctly. So I'm not certain.
We're going to deal with the Verizon matter here. All right.
Certainly, Your Honor.
You shouldn't have been thinking about it this morning. You put too much thought in that. All right. We're going to deal with those 4 issues. All right. First issue is life insurance, right? Just as a practical matter, and Mr. Swears, you even indicate that, how is anybody supposed to know that he has life insurance if they can't find it? And I know you say there's nothing in the order, and this, I'm going to deal with this order as the 4 corners, okay? That it doesn't say that he has to show that he does, but it also doesn't say that he doesn't have to show that he does. I don't know what else to say. And this is just a practical. How is she ever supposed to know that he has insurance? And I'm not saying that he has to tell her every week, but what can possibly be wrong with him having to provide that information on a yearly basis, on a 6-month basis, in a format that's quite simple? How else is anybody supposed to know?
Oh, I agree, Your Honor. On a side note, this isn't, I suppose, of legal effect, but I'm working on getting appropriate documentation, and I'll reach out to Mr. Cox because I agree there has to be some reasonable verification. But I think the concern, what the court can read from the rest of the motion, is we entered into it under specific terms under the concern that this was going to be a provision that was overused or creatively interpreted. So I agree with the court that there's absolutely no problem with having some level of reasonable verification on the insurance. If the court is inclined to amend to add that, we would ask that it be very clearly defined, very infrequent, annual at most, simply because this is not a situation where we defend it.
It would be annual, but it would also put a burden on your client to inform them if there is any change in that insurance. Okay? So that he can't, okay, he informs August 1 and he doesn't have to show proof until the next August. But he has to have an affirmative duty that if there is a change in that insurance, that he has to notify promptly, because I don't want him going until next, he cancels it 3 days after he informs and she's again without it. I don't have a problem. These parties are divorced. Okay. Mr. Cox, do you agree with that?
I do, Your Honor. And I think that resolves the issue. And in terms of just a quick response to Mr. Swears' observation, I mean, frankly, I think the opposite. I think, Mr. Steele's refusal to just simply email a document that would take 2 seconds to email over to his former spouse is indicative of the other problems that we're going to address.
It's indicative of 2 people that don't get along, and it's no more his client's fault than your client. I'm just telling you that right now. All right. So I will state that there should be that done. Can Mr. Swears and Mr. Cox, can you come up with appropriate language, which I have just told you? He has to, let's say, annually provide proof, but he also has to have an affirmative duty that if it changes, he must inform immediately. All right.
Yes, Your Honor.
Mr. Cox, that will be resolution of that issue, unless you have something else you want to add.
No, thank you, Your Honor. I am writing down that language, and thank you. Nothing further on that topic.
All right. Number 2 is I got for family pictures. All right. Mr. Swears, you have said in your pleading basically that he has the family pictures.
Yes, Your Honor. I believe we could resolve this as outlined in our hearing. Just authorize my client to pick a local professional digitization company, get them, and just do this. I think the issue is the part is agreeing, no change to the ultimate.
That's exactly what I was going to do. I'm going to give him 2 weeks to do that. It has to be a professional. I mean, it has to be picture quality type digitalized for as much as I know about that.
I'm doing it with all my grandmother's old photos. I've got a few people I can recommend to my client. We'll get it done professionally.
It will be his cost to do that because she's going to get the digital photographs and she's going to have to pay to print them off. No. She wants it. All right. And can it be done I mean, I'd like to set a time frame like 2 weeks.
I think it can be initiated, Your Honor. I would defer to the company itself as far as I don't know how fast the machines work or
I don't know
any of
either.
that.
And I don't know how many pictures they have.
Yeah, but I will also keep Mr. Cox reasonably informed and we'll coordinate that. So we know there's progress.
Must
being
do
made.
that within 2 weeks. And like I say, if you go to Mr. Cox and say, I've got it all to him, they're saying it's going to take 14 days to have everything done and put on a drive or whatever, Mr. Cox will, of course, be reasonable about that. I just want it done. All right.
Certainly, Your Honor. And speaking of getting it done, just to clarify, so we're not arguing over this down the road, my client has a particular interest in 3 large pictures of the children that were photographed at a beach that she had framed. So she asked me to emphasize, please make sure that those are included as part of the photographs.
That photographs are photographs and he has them and he'll have them digitalized. And and the 2 of you can talk about, that kind of stuff. I'm not going to be involved in going through the pictures. All right. So just make sure. And Mr. Cox, if there are those photographs and stuff, make sure that, contact Mr. Swears so that he knows that. I appreciate it so that we don't forget something. Maybe there's a picture hanging on the wall and she wants that. And he didn't think, oops, yeah, I just thought I'm in the drawer that we got here. All right.
Thank you, Your Honor.
All right. Okay, Mr. Swears?
Yes, Your Honor.
All right. Cool, boy, we're making progress until we get to this one.
Well, I was going to ask Ms. Steele, I'm not with her. Could she turn her video on? Because I have to figure out if she's mad at me or not.
Yes. Mr. Steele was on until he just.
Oh, okay.
All right.
Carrie, am I in trouble yet? Or are we doing good so far?
Mr. Steele, this is what you've requested, all right? And Mr. Steele, you understand what is going on so far. Both of you don't have to answer because you got attorneys, but let's see. All right, next one is personal property. This one's much more difficult. First of all, Nikon camera should be returned to mother promptly because it is stated in a document that is filed here that your Nikon is here. What do you want me to do with it, in effect? That's part of the judgment that's, your Nikon camera is still here. Do you want it? And she says, yes. That's from a year ago. That is something that is within that judgment that she is to get the stuff that is hers. When you classify it as your Nikon camera, you're responsible. All right. As far as the wicker furniture, I don't know what, there's a lot of it there. What's your plan? I don't know what to do with it.
Well, I think,
hey, Jordan, am I allowed to speak here for a second? Or
hold off here. We'll touch base afterwards, but I
okay.
think I understand enough of this case. I understand the court's point of the Nikon camera, Your Honor. I think the wicker furniture really gets to the other point, which is at a certain point, once things are divided, I don't want to get ahead of the court may already be.
And here's my problem. This is now the problem to Mr. Cox. All right. Exhibit A is not referenced anywhere in the judgment. There's nothing in the judgment, and I can't enforce Exhibit A. I don't know when it was drafted. I don't know. I mean, I just have, nothing, and you know what I'm talking about is Exhibit A here, all this
Yes, sir.
stuff. I don't have it. I don't have either party's signature on it. I don't have anything, and the court just can't enforce something that's not in the judgment. I have no problem, like I say, with the Nikon because he admitted it's hers. And in the judgment, it says you turn stuff over that's hers. That's fine. The wicker furniture, I don't know what to do with it. It's listed on Exhibit A and he said, here, do you want it and things? And I don't know what to do with that. However, other stuff that is requested is simply not within the confines of the judgment anywhere. And I can't go outside of it. So, Mr. Cox, what are you, that's what I'm gonna rule because it's.
No, Your Honor, I understand exactly what you're saying, and I understand exactly why you're saying it. So I can't make an argument to that, but what I would try to point out though is that the judgment does say expressly that each party will retain the household furniture and furnishings in his or her possession. Here's the important part. And any disputed household furniture or furnishings will be divided by alternate selection, or we sometimes call it round robin. So that was supposed to occur, and unfortunately, in this matter, the plaintiff just refuses to do it.
Well, but it's a year, and I don't even know. Here's the problem: nobody, your client didn't do it either. All right, neither client did it. That's the problem that I have. Yes, they're supposed to do it, but you know, she can say, "Gee, you know, he wouldn't let it." We could have come back on this last September and said, "This is the furniture that's out there. They're supposed to do it round robin," or you know, I know what it is. You pick first, and I pick second, and go on with that. I don't even know what furniture or what not is left and what is in dispute, and we're a year away from it. What do you think I am supposed to do? Because each of them, I take it, has furniture. It's in his possession. What she's got's in her possession. What am I supposed to do? Order the couch to be back?
Yeah, I mean, we were just trying to get him to do what he was supposed to do, and we've shown through text messages and emails that my client made several efforts to do that, and he just refused to cooperate with her, much like he doesn't want to give her an insurance. I mean, I don't.
I understand what you're saying, and you also understand that it's within the parameters of the judgment. And this is like me getting down to saying, okay, who gets the bird cage and who gets the, I don't know who gets it. I don't even know what they have that's still together, or that they are supposed to take turns selecting. This should have been done in August of last year instead of now. And I don't know that there is anything. What is left?
Exhibit A, Your Honor. I mean, that's.
But Exhibit A is, I don't know if she's got some stuff from it. I don't know. You know, Exhibit A was not in there. If Exhibit A would have been referred to in there, it'd be different ballpark. But it's just, it's almost what I'm saying. It's almost impossible to enforce at this point. I don't know what I can enforce.
We sent them Exhibit A back in November of 23, and they acknowledged that. We just were never able to.
Well,
you know,
but
is
I'm
he
not
saying
gonna
then
get
that
into
all
it now.
that
Just-
property is gone?
all he
I don't
does-
know. Yeah.
All he does is sit here and shake his head, which isn't very appropriate, but he shakes his head no to everything. And I'm just saying, Mr. Swears, you know what he's saying. You can, and you also know where I'm going, so you're in a catbird
Well,
seat.
I think the court's got it dead on. Is if this were July of last year, when they were still in the same home, we get together, we do alternate selection, we're good. At this point, short of Ms. Steele moving everything back from Ohio to Michigan, lining everything up, we don't know what's been divided, what's not. And we're talking, I mean, calico critters and the wood tracks on a Thomas the Tank Engine. The parties are married 26 years. I get there's no, everybody's going to be happy way to divide it. If this had been filed a year ago, we might have a resolution here, but at this point, it's essentially, I mean, even in her motion, she says some of the things I want weren't included on the exhibit. I think at this point, the parties are divorced. You got what you got. We'll resolve the couple of items. We'll get the Nikon camera dealt with. But apart from that, I think the only thing we can do is just go, yeah, getting divorced after 26 years is not cut and dry. And I just don't think there's a way the court can go back and.
I don't either.
Certainly not for these sorts of items.
Because what if we go to Exhibit A, and I don't know if she has some of Exhibit A or doesn't have some of it, and if she does, which ones we take out, and then do we start picking one? What the problem is, and thank goodness, I don't have to divide the calico stuff and things like that, because quite honestly, it's a year down the road and by now it should have all been taken care of. And I'm sorry, I believe the Nikon is right there and Mr. Swears, if he's done something with it, he's responsible because he says it's hers and she didn't get it. All right.
I understand. Regarding the camera, I understand, Your Honor.
All right.
It's different. There's the email. I understand what the court's referencing.
So other than that, I just can't, I don't think there's other personal property to be divided unless you and Mr. Swears talk and you guys agree to something, that's fine. But other than that, the court is not inclined to enforce anything further than that. For the reasons, and I know you know what I'm talking about, Mr. Cox, this is not your first rodeo. So, and I know Mr. Swears knows because he called my decision brilliant because it was on his favor. Unfortunately, he doesn't call my other decisions brilliant because they're not, right? So that issue being resolved, we go to Verizon, and as far as Verizon goes, they've each got their own phones and whatnot, and that's water over the dam or under the bridge or something like that. They've each got their own phones. She's got her own account. No matter what happened to get it or whatnot, she's got it. And I'm not going to go back. I don't even know what you want. You want him to pay for, the most that I can tell you is Mr. Swears, if he has this phone listed as stolen when he knows it's not, go to Verizon and tell him that it's not stolen.
I understand. I think the problem is he wouldn't have been able to report a phone stolen that is on her account with her number. So I understand the court's point. I also have no idea what the deal is with
I don't
this.
know. I've
never worked at
phone at
Verizon.
Verizon and I don't know anything they tell me when I walk out, what I've got or anything. They tell me a lot of stuff and I go like this and then I walk out and I hope it can text and I hope it can ring. Other than that, I don't know. So I'm just telling you now that if there is something that he has listed her phone as being stolen, that number, to contact Verizon and say it is not stolen. I don't care about anything else.
Yes.
And certainly if Mr. Cox has anything regarding that would help me kind of give
Certainly.
my client what he
I'm
needs to
happy
tell
to provide
Verizon. I'm
that.
sure he'll, yeah.
So
Sure, I will do that, Jordan.
I want him to contact Verizon within the next week and make that statement if it is there or not. I just don't know. All right. And it only pertains to her phone, her number. And I can't understand why Verizon would think her phone was stolen if she got her own account and whatnot. But again, I don't understand anything. I'm just telling him that he should do that for whatever reason. All right. Anything else that I think I did the 4 things that we looked at. Is there anything else that I should address, Mr. Cox?
Your Honor, my client is asking for her attorney fees for having to file this motion.
There's some things that I'm going to respectfully decline. There are some things like the life insurance that is not clear in there. It is, and the personal property and things like this. I think there were legitimate issues, and I'm not going to give attorney's fees at this time.
Thank
I
you,
mean,
Your Honor.
any other violations of this order, if he doesn't go do the family pictures in 2 weeks and you have to come back, you can bet you're going to get attorney's fees then.
Thank you, Your Honor. Understood.
Mr. Swears, anything else other than you want to reiterate what a brilliant decision I made?
Well, that and just to, I assume Mr. Cox is preparing the order because with great attractiveness comes great order preparation responsibility.
Doesn't the most handsome dude have to prepare the order? So it looks like I'll be stuck with the order.
By default, you're always going to get stuck with drafting the orders from now on. In any case,
Yeah.
good luck, everyone. Thank
Thank
you for your patience and your professionalism in this matter.
Thank you, Your Honor. Have a good weekend.
Have a good day. Thank you.
Take care.
Both parties are present.
Yes.
Down here, as well as we have attorney Canfield for you represent the
Plaintiff. Good morning.
plaintiff. All right, yeah, the father. This is Mrs. ordered or is requesting an order of mediation. So she needs it to help all kinds of stuff. I'm just asking you, counsel, you oppose the order?
No, at this point, I've sent Ms. Tipt an email this morning. I've spoken with my client. We agree that we could go to a second mediation. However, I think both parties did not make a lot of progress with the initial mediator, so we want a different mediator. However, we will not agree to the mediators presented by the defendant, I sent her a proposal of 4 additional individuals, which are typically utilized within this county, as
Who are
I
you
am
proposing? You
familiar
can tell
with.
me right now, who are you proposing?
I proposed David Sarnacki or Victoria Drake or Sean Perry. I think the final person was Michael Dantamon.
Familiar with most of them?
Are you asking me, Your Honor?
Yes.
No, because I'm not in the field of law and I'm representing myself, that my concern is that Miss Canfield would be picking people that would be partial to her or her ideas and therefore would put me at a disadvantage.
Then
It's
I'm
already,
gonna get to the point of I'm not gonna even order mediation because you guys can't even agree enough to get a mediator, okay? I happen to know, I know Erin Magley, I know Elena Elliott, I know Margaret Allen, I know the ones that she just did. I could easily pick a number of people in a heartbeat to do this. But if you guys can't even agree on a mediator, what are the chances a mediation is going to get anywhere?
Your Honor, I felt if there was an objective person, then they could help us come to an agreement.
I'm
since we are
telling you
different.
that I'm telling you right now that I know that Michael Dantama is well respected. I have nothing that I gain by sending anything to Michael Dantama, but he is absolutely a great mediator who is not partial to anybody. I don't even know if Ms. Canfield even, what is your connection with any of these?
I have no connection with any of these.
All right, let me ask you this.
They're not in
Why
my
do you
town.
object to Margaret Allen?
I'm just not familiar with Miss Allen.
I am, okay? Very familiar with Miss Allen. She is practiced here, does all kinds of abuse and neglect and is a wonderful, kind person, all right? I'd recommend her in a heartbeat.
All right. That's
All right?
fine. I've
And
seen my
it has
client
nothing
nod
to
his
do
head.
with- It has nothing to do with anything other than Margaret Allen, okay?
Certainly.
Hopefully she's available, all right? And I think then Margaret Allen could be the choice. If Margaret Allen is not neutral and doesn't do a good job, then I have been fooled for the past, I don't know how many years, all right?
Fair enough. We'll accept the court's recommendation in that regard.
Ms. Tift, you'll agree to it also.
Yes, of course. Thank you.
All right, then contact Miss Allen as early as you can. See if we can set something up. If it turns out that Miss Allen cannot perform it, in a timely manner, since I took that one off your list, who is Michael? Dave Sarnacki is a world-class mediator, but I think he's pretty expensive. Mr. Dantama is also well-known around here as being a frequently used mediator, all right? And they don't become frequently used unless they're any good. So, Ms. Tift, if Miss Allen cannot do it because of availability, I guess I would suggest you don't know either of those, do you?
No, I do not, sir.
I would take, if there is a cheaper one between Dave Sarnacki and Mike Dantama, I would ask that, who was the other one? Oh, Sean Perry is usually very reasonable, is less expensive.
And Sean might have a little bit more availability.
Yeah, but I want Margaret Allen to do this, all right?
Sure.
And unless Margaret, she's also kind of busy, and unless Margaret Allen says, yeah, I can get to it, but I can't get to it till 1st of September, it's probably not worth it, all right? So if she can get to it within the next couple of weeks or whatever, that's great, all right? If she can't, and it looks like she can, all right, then I will choose Dave Sarnacki as the next one.
Okay.
All right.
And your honor, is it something that can be scheduled right away and so that
That's something that I can't control because those are two attorneys who I have no idea what they're doing. All right.
Yeah, I meant as far as Miss Canfield goes.
She will have to do the best she can to get there also. I mean, I can't let, you, Ms. Camfield, be the logjam in this, but I do
Right.
also know that you are a practicing attorney and don't just have every day available. I want
That's
you to make
correct.
yourself available as much as possible so we can get in there and see if we can get somewhere, all right?
Certainly. We
All right.
have a little bit of time. We've got trial scheduled for the end of August, so we have a few weeks to work with here, but sooner rather than later, certainly. is what-
Yes, I'm gonna trust Ms. Camfield to make sure that she's gonna, just because somebody says, yeah, I can do it next Friday, and she says, wait a minute, I got motions next Friday and I got this and that, that's one thing, okay? But work with it, make this a priority, and we will have Margaret Allen if she cannot do it, then what did I say, Dave Sarnacki?
Correct.
Yes.
All right.
Your Honor, Miss Camfield has said she's busy. She's already booked and can't do mediation. She stated in an
She
email
just
to
told
me.
me right now that she will go out of her way. Don't,
Oh, good.
you know, this is
Good.
the problem why I'm afraid mediation isn't gonna work, all right? Because no matter what I say, you're going, oh, no, 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 oh, no, no. All right, both
Okay.
parties have got to be in a mood to mediate,
Yeah.
or else it's not gonna work. So she will not be a detriment. You don't, let me just ask you this one question. Do you have any big vacations coming up, Ms. Camfield, between now and mid-August?
Actually, yes, I do. I have 2 weeks off because I will be out the last week of July and the first week of August.
Then make sure it's scheduled before you go.
That only leaves next week and the
You
week following.
You just told me that we got some time, all right? I
Well-
need it to be done, all right? You figure it out. I'm not gonna order you to, cancel your vacations and stuff like that. Just get this done. All right?
I'll do my best. I'll see if somebody
Good
else.
luck,
can cover it as
everybody.
well.
You
Thank
can, Ms. Camfield, you can draft the order that appoints the mediator. Good luck. Thank you, everybody. We're adjourned.
Thank you, Your Honor.
Sullivan versus Sullivan. Ms. Sullivan is present. She's the plaintiff. Can you hear me, sir?
Yes.
All right. Mr. Sullivan is also present, both of them via Zoom. This is a motion by the plaintiff to revise the temporary order. The judge made a temporary order in this case, basically June 1st. It was actually, I think, 5/31/24. Lists exactly who has to pay what in there. Basically, it says the plaintiff shall pay the defendant's rent upon proof of that rent and to pay $275 plus that rent until further order of the court. She doesn't like that anymore and wants, like, early September to change it. I think you're asking for 500 total. Is that correct?
Yes, I was proposing that I pay August as well. And then for September, October, and November to pay 500 total so that he could acclimate to being financially independent.
Mr. Sullivan, what's your response?
I recently had to quit a job because I couldn't physically do it. I'm still recovering from heart surgery, still doing physical therapy twice a week, and still need to do my cardiac rehab. I'm not physically fit to do most jobs.
Are you providing her rent information on a monthly basis?
I am.
How much is that?
I believe it's 1135 or 1165.
All right.
I'm not sure.
And ma'am, you've been paying that plus 275, right?
Correct.
All right. Well, sir, you were also defaulted on 5/17. You understand that, don't you?
No.
I think there's a default in here. Did you ever answer?
I never had a correspondence.
Yeah, you did. You had a complaint filed against you. The complaint for divorce. Did you read it?
Oh, yes, that was prior to these motions.
Yeah, but what does it say in the summons?
Says that she
There are
filed
21 days after receiving the summons and a copy of the complaint to file a written answer in bold print with the court and to serve a copy on the other side or to take other lawful actions with the court 21 days served by mail.
I was under the impression that that was only if I wanted to dispute the divorce.
Well, you don't know what you're doing. I'm telling you right now, you were defaulted.
Okay.
However, and that's could result in problems for you coming down the road, but I'm not gonna deal with those. At this point, ma'am, I'm gonna deny your request. Judge Hillary ordered it. You can bring it up to him again, but this divorce is gonna be over with sooner rather than later, I would hope. I think it was filed
April 18th.
April 18. May, June, July, so you're halfway into it already.
Mhm.
Get it done as quick as you can. Good luck, I'm gonna deny your motion at this time, man.
Thank you.
Okay. What vote tonight?
There was a second motion filed at the same time. However, Anthony and I have been working to refine that parenting plan and would not like to proceed with the one that was presented.
Right.
So if we could deny that one as well.
All right, thank you very much. Thank you, ma'am, for doing that. I appreciate it.
Am I? So part of that parenting plan was to set communication and behavior standards. Is there any way that we can have that established during this meeting? Anthony is harassing me and making the exchanges incredibly hostile, including swearing at me, calling me names, striking my vehicle. So I would just like something.
Let me just tell you, it's really not part of this motion, but I will tell you, Mr. Sullivan, all right, listen, if you do that kind of behavior, it is not going to go good for you throughout the rest of this divorce and in the future as it relates to your parenting time with your child. If you do not treat her the way you want to be treated, which I'm not saying you did this stuff, but if you do any of this stuff, if you want her to treat you that way, if you want her to pound on your car or swear at you and yell at you and stuff like that, well, she doesn't want it, all right? And if she needs to, she may consider coming in and getting some kind of a restraining order, even if it's a mutual restraining, civil restraining order regarding that. I'm not issuing one right now, but I'm telling you on the record, so she can get a copy of it. If you continue that kind of behavior, I'm gonna set some real strict rules for you. You have a child together. It's time that you act like an adult.
Okay.
Do you have any questions about what's expected of you?
Nope.
I don't care what you think of her, or she's getting a divorce and all this kind of stuff, and that will not translate, especially when you're making exchanges and you have a child and this kind of stuff. Ma'am, if he does that kind of stuff, my suggestion is, I'm sure you have a phone with you when you're making an exchange. Just put on the video camera for a minute, have him do something stupid like that, and then file a motion, and I will do something to you, sir, and it won't be favorable to you. You can act like a reasonable adult every time. You don't email her and you don't call her names and you don't swear at her and you don't do this kind of stuff. You're a grown adult. That's as much as I'm gonna do with that right now, but ma'am, if you come back and you can prove that he's doing that stuff, me or Judge Hillary will see to it that something appropriate happens.
Thank you.
Thank you. Good luck, everybody. We're adjourned.
Thank you.